Good morning. We have a quorum and we'll start the COPRAC meeting. This meeting is being recorded. If you are a member of the public and would like to give public comment, please use the raise hand function to let us know. So with permission of the chair, I'll start roll call. Yes, thank you. Sarah Pinola. Here. Ken Bacon.
Here.
Elizabeth Bradley. Here. Raquel Brigham Brown.
Present.
Cassidy Shivers.
Here.
Justin Fields.
Here.
Brandon Krieger.
Here.
Paul Mark. Eleanor Mercado. Bill Munoz.
Here.
Daniel O'Reilly.
Here.
Kyla Rowe.
Here.
And Hunter Starr. Thank you. Are there any members of the public here who would like to give public comment? Not sure, but we do have one person who wants to give public comment, Isabella Lee. So I'm going to allow each person 90 seconds to speak. And then at the 10-second warning, please wrap it your comments. So Isabella, if you'd like to speak, you can start.
Good morning, everyone. Yes, my name is Isabella. I'm a law student at UCLA, and I wanted to comment on the first item on the agenda regarding the illegal contract provisions. I just wanted to say that we are watching as law students. We're wondering why it's taken so long to have the opinion made final. We feel that California should be an example for the rest of the country, and that lawyers' jobs are to make sure that contract provisions are in fact enforceable. And the fact is, including these non-compete agreements harms workers and has so much potential to be coercive against unsophisticated parties. So as law students, we hope that the board will pass this through.
Thank you. I just wanted to note that the illegal contract opinion item is not on the agenda for today's meeting. It will likely be on the agenda for our next meeting. So in case you're planning to stay, it's not currently on the agenda for this meeting, but it will likely be on the agenda for next meeting. And then we have Jimmy Deegan. You can start, Jimmy.
Hi, can you hear me?
Yes.
Okay, thank you. My name is Jimmy Deegan. I'm also a law student at UCLA, and I am calling in to echo what Bella is saying. We are just wondering why these legal protections are taking so long, and why the acts of legislature, why they're not protecting workers as they were meant to. Yeah, thank you.
Next, we have Terry Gerstein. Terry, if you want to start your public comment, I believe you're on mute.
Hi, my name is Terry Gerstein. Oh, sorry. Can you hear me?
Yes.
Okay. My name is Terry Gerstein. I direct the state and local enforcement project at the Harvard Labor and Work-Life Program. I am also a senior fellow at the Economic Policy Institute, and previously I enforced the labor laws in New York State for 17 years, including as the Labor Bureau Chief in the New York Attorney General's office. I understand that the draft opinion about illegal contract provisions, you just said it was taken off of the agenda, although I note that it still seems to be on there for today. And I just wanted to share my perspective as someone who has spent many years representing, handling cases in not representing workers directly, but representing the state in cases involving low-wage workers, often immigrants, people of color, in wage and hour retaliation, and in my final year in the Attorney General's office, some non-compete related cases. And just many workers, especially low-wage workers, don't know their rights. They don't know the rights in relation to overtime, minimum wage, sick leave, and definitely not in relation to non-competes. They don't have access to lawyers or legal advice. And people rely on their jobs for their livelihoods. They live paycheck to paycheck. And I've seen firsthand how when people are hired, there often is no negotiation. They're told take it or leave it, and there are few options. They don't know what's in the paperwork. And allowing members of the bar, when lawyers from a sophisticated corporation insert a clearly prohibited and unenforceable clause in an adhesion contract with an unrepresented and less legally sophisticated party, there's a great disparity of power, and there's not really any possible valid and legitimate purpose for including that clause. The only reason would be the chilling effect, which is fraudulent and unethical, and members of the bar shouldn't be facilitating that kind of predation. So in relation to that opinion, just wrapping up, it's really important to send a clear message that including in employment contracts, a provision that is prohibited and unenforceable is really unethical conduct for an attorney. Thank you.
Thank you, Terry. Are there any more public comments? Carson McKinney is next. Carson, you can unmute yourself and begin.
Hi, yes. I am also a law student. I'm also confused why the agenda item on illegal contract provisions is not on the agenda, since it is still appearing online as on the agenda. And I would just like to echo some of what's been said and say that as law students entering the legal profession, just confused why it would be allowed to include illegal contract provisions in employment contracts. So I'm just concerned about the ethical implications as a young lawyer who will be entering this field.
Carson. And next we have Neil Wortley. Neil?
Hi, thank you very much. I am a practicing attorney in the state of California, former chair of COPRAC, and I appreciate the comments from the prior public speakers. And while I agree that it is unfortunate that non-compete covenants are included in contracts against employees, the right venue to discuss that issue is with the California legislature. Once it is illegal conduct on the part of an employer to impose a non-compete, then by operation of the rules of professional conduct, it would be unethical for an attorney to assist the client in that behavior. But unless and until it is clear that it is illegal behavior on the part of the employer, there's no ethical constraint on the work of the attorney.
Thank you, Neil. Are there any more public comments? Terry, you have your hand up, but I believe you've already spoken. So having said that, I think that concludes the public comments.
Okay. Thank you, everyone, for your public comments. And we will likely be addressing this item at the next COPRAC meeting. I think now we have a staff report.
Sure.
Okay.
Good morning, everyone. So my staff report is brief. The only thing I wanted to speak on is that the Board of Trustees at its September meeting did issue for a 60-day public comment period, the ad hoc commission's report and recommendations. For those who may not be aware, the ad hoc commission was meeting in regards to exploring possible changes to the discipline system in light of several reports that came out, including the attorney disparities report that indicated that primarily male Black attorneys were being disciplined at higher rates than their white male counterparts. And so in response to that, a commission was established, and they have issued report and recommendations that has several recommendations, some of which include exploring reducing discipline costs, for example, exploring changing the early neutral evaluation conference process and when that conference would be available, among other things. So that's something that this committee may want to explore looking at, as well as possibly giving comments on.
Erica?
Yeah.
Do we have another meeting before the comments are due?
Let me actually pull up the deadline on that. I apologize if I don't have it.
I thought it was November 24th, so there might not be
I think that's right. It's at the end of November, but depending upon, it is possible that there could be an additional public comment.
Oh, okay.
It could be extended, in the sense that it could be issued for a second public comment period.
It says November 28th.
Okay. Yeah, Ken just confirmed, I think, from the website that it's the 28th. But we could also, COPRAC members could submit individual comments on your own
Correct.
behalf, since you won't have a chance to comment on it as a full committee.
I have nothing else to report.
Okay, well, thank you for the update, Erica. And because this is our first meeting with new members, and also Justin pointed out earlier in our orientation that we believe this is the largest in-person meeting we've had, at least since I joined the committee in 2000, or since, sorry, March of 2020, when the COVID pandemic began. So I thought, since we're all in this room, that it made sense to kind of, so everyone gets to know one another, just go around the table so we can do very brief introductions. And I recall at my very first meeting where Steve Bundy was the chair, he also encouraged everyone to say something about yourself, not necessarily related to your work, but a little personal tidbit or hobby, just so we can get to know one another. And then we'll move on to the agenda items, but I just thought it'd be nice to start off the meeting with introductions, since we're all meeting for the first time in person in a long time. So I'll start. I'm Sarah Benola. I'm the chair of COPRAC. This is my first meeting as chair. And I am a partner at BRB Law. It's a law firm in Oakland, which I founded with some colleagues in March of 2021. And my practice focuses on regulatory law, employment law, and legal ethics. And just a little personal tidbit about me, about a hobby. In college, I was a softball pitcher, and most people wouldn't think that, but I was, and I still enjoy playing softball. I just went to the batting cages with my son, and he was impressed because I hadn't played in a while, that I could actually hit the ball that was going that fast. So it was really fun going to the batting cage with him. My son's 9, and so I'll move on to Justin, who is the advisor for COPRAC, so he can share some information.
Hi, everyone. I'm Justin. I'm a partner at Dwayne Morris in San Francisco. My practice primarily involves lawyer liability defense work. This is my 6th and final year on the committee. Feels like it's been forever that I've been on COPRAC. Looking forward to this year. Something about me, I'm trying to think of things I haven't said in the 5 other icebreakers. I guess I haven't shared that I'm an avid but terrible gardener. I probably kill more than I grow, but I did successfully grow some purple carrots over the last couple months, which was a pleasant surprise. My kids ate them, which was even more of a surprise. And yeah.
I'm Brandon Krieger. I'm a partner at a small law firm in Laguna Beach, California. The tidbit about me is that I'm born and raised in Wisconsin, so Laguna Beach is the best place I've ever could imagine working. I do almost entirely plaintiff side legal malpractice work, so it's a pleasure to sit next to Justin.
It's the beauty of COPRAC,
Yes,
right?
yes.
We all get along.
Good morning, everyone. My name is Angela. I'm a program analyst with the State Bar staff. Anything you need help with, feel free to reach out. And my hobby is old-fashioned film photography.
Cool.
Good morning. I'm a new member, Raquel Brown, non-attorney, public member, background in business management leadership. Congratulations on your carriage, Justin.
Thank you very much.
I am nurturing a tomato plant, and I went away for a week. I gave my husband instructions, just water it. Just make sure you spray the leaves. The tomatoes grew, but the leaves did not. So, I, not necessarily a hobby, but I just got back from ringing the bell on the New York Stock Exchange. So it wasn't on my bucket list, but I got invited to be part of a delegation. And it's everything you see on TV. Happened to look to my right and I'm like, that looks like the guy from Shark Tank. Why is he here? I said, hi. And he looked at me like, do I know him? So I said, I don't know you. I mean, you don't know me. I know you from Shark Tank. So that was kind of interesting too. So that's me. Look forward to working with the team.
Good morning. I'm Erica Doherty. I am an attorney in the Office of Professional Competence and the attorney for this committee. I have a 5-year-old and a 2-year-old, so I have no hobbies. I do run occasionally, but that's about it. But good to see everyone in person. And it looks like we have everyone in attendance today, so that is wonderful.
My name is Hunter Starr. I've been on the committee for a little while now. It's been a learning experience because I'm a homicide prosecutor. So I don't do a ton of anything outside of Rule 3.8. I have a 5-year-old and a 3-year-old, so
yeah.
I get it. But one of my, I guess, a tidbit about me is I was sworn in to the California State Guard this year, and I'm a judge advocate, and I get to help soldiers in the National Guard.
Hi, I'm Dan O'Reilly. I am also a new member this year. My practice is advising California law firms on both the business and ethics side of their practices. And an interesting fact about me is I grew up in Buffalo, New York, and I am not only a Bills fan, but I have trained my son to be a Bills fan, passing on the blessing and the curse. Blessing this year.
Yeah.
It's looking good.
It's looking good. Don't jinx it.
I'm Elizabeth Bradley. I'm a partner in Rosen Saba LLP. We're a South Bay firm. My practice is just like Brandon, almost exclusively plaintiff, legal mal, and ethics matters with some employment, and I do all of our firm's appeals as well. My favorite thing is to travel, so I'm excited that I finally got to go after all this pandemic on a 3-week trip to Italy that I'm kind of still jet lagged from. I should drink a lot of wine, which is another hobby of mine. Unfortunately, the only plants I've planted in the past 20 years died while I was gone. So I have something to work on that front. I am a Dodgers fan, although I'm from San Diego. Go Dodgers.
All right. Everyone, I'm Bill Munoz. I'm from Sacramento. I call myself a full-time mediator, but I also do expert work in legal ethics. Prior to that, I was a defense attorney handling legal malpractice cases for Murphy, Pearson, Bradley, and Feeney. I ran their Sacramento office for the last 12 years before I retired. Fun fact about me, I love going to concerts. I love live music. I saw my first country concert in lieu of Guns N' Roses, not Guns N' Roses, in lieu of Motley Crue, because I couldn't get a flight from Sacramento to Vegas, because I was telling Ken, it's the only time in my life I was flying that I get a text. I wake up that morning, your flight's been delayed 2 hours. Okay, so I adjust my schedule, head to the airport, get a text message saying, oh, the original flight time's back on, and I'm 30 minutes from the airport. And it was 30 minutes before the flight's leaving. So I missed the Motley Crue concert, although I've seen it before. So thankfully, I didn't miss much. And I have a 17-year-old high school senior, so I'm going to be an empty nester here in 10 months. And I'm clinging on to these next 10 months. So you have a little time, but, cherish it. And I'm getting ready to send one off to college. I'm like, but that's it.
Hi, Ken Bacon, also from Sacramento with the Mastagni Holstead firm. I do the in-house risk management and ethics for the firm. Nowadays, outside of that, I mostly do plaintiff's legal malpractice, some fee arbitration. I was with before COPRAC, which is, I'm now in my 4th year with COPRAC, I was on the fee arbitration committee for many, many, many years. Before that was disbanded, presiding arbitrator for a number of years. I took over after Joel. Hobbies wise, I'm similar, except with me, it's my 2-year-old granddaughter who happens to live right next door and occupies almost all of my time when I'm not at work, and I am incredibly joyful in having that experience.
That's cool. I'm Cassidy Chivers. This is my second year on CoPrac, and I'm with Barron and Newberger. I opened up their Mill Valley office in Marin County, which is one person, me. It's an Austin-based firm, though. And I do legal ethics, risk management, and some legal malpractice defense. And I've been doing that for 20 some odd years. I was with Hinshaw and Culbertson prior to moving over to Barron and Newberger last year. Let's see, a hobby, kind of like a combination of Elizabeth and Bill, because I love to travel and I want to go back to Italy so bad. And my daughter, who's 13, we went in 2019, and my daughter, who's 13, she was 10, saw her first concert in Lucca. And it was New Order. So it was a wonderful, I'm not a big concert person, but it was a great outdoor, beautiful concert. And I can't wait to go back to Europe soon, hopefully in the next couple of years.
Well, that was good to get to know everyone a little bit more.
On the screen.
Our colleague on Zoom.
Oh, yeah, I'm sorry. I'm not used to this hybrid environment. I apologize. So Kyla, did you want to start?
Yeah, hi. Hello, everyone. Sorry I couldn't make it. I'm zooming in from Santa Cruz. Kyla Rowe, this is my, I think, 3rd year on CoPrac, although time during the pandemic really, everything blends together. So I have no idea. But I'm a content attorney at CEB, Continuing Education of the Bar. I've been doing that for about a year and a half. And before that, I practiced commercial real estate transactions. And a tidbit kind of similar to Sarah, I played college tennis and kind of took a break after college. And this past weekend, I got back out on the court for the first time. And unlike Sarah, it was not a very happy thing. Nothing destroys your ego like trying to play a sport when you're like 15 years older and don't practice it for 4 to 6 hours a day. I'm like running and I'm like, I used to be able to get to that. Like I used to be able to hit so much harder. So it was humbling. And I'm also a gardener. I'm actually, I think I mentioned this at the last icebreaker, but I'm taking horticulture classes at the community college and getting a degree in permaculture design. And Justin, I can tell you, I'm taking a class right now called Edible Landscaping. And the professor started the class by saying, if you don't kill more than you grow, you're not doing it right, because everything should be an experiment and you should be pushing yourself to try new things. So keep killing the plants and then hopefully you'll find some that you get a little more confident in. But yeah.
Nice.
Oh, Mimi, did you want to introduce yourself as well, please?
Hi, I'm Mimi Lee. I work for the State Bar. I work with Angela and Erica. I've actually staffed this committee for 16 years. So I've seen a lot of people come through and all the good work that we've done. Just like Angela, if there's anything you need, let me know. I can help you with, any kind of research or finding old opinions, those kind of things. In regards to hobbies, I guess my big hobby is I'm a huge Formula One fan. And so me and my husband, we travel the world attending races. So we've already attended 5 so far. We've done Italy, which was absolutely amazing. Belgium, France this year. We've done Japan and we've done Texas so far. My bucket list is to hit every single track and see a race there. Also, I've tried gardening too. It's new for me, considering I can't keep an orchid alive, but I was really proud of myself because I was able to grow mint. But then I found out that mint is like the easiest thing to grow because it's technically a weed. So not really too much of an achievement now. It grows so fast. I don't know what to do with all the mint I have. So if anybody needs mint, let me know.
And orchids are really hard, so
Yeah.
don't be hard on yourself.
Mine just keeps getting fuzz on it, or they just die. I don't know what I'm doing wrong.
Okay. Hi all. I'm Joel Mark. Now I'm in my third year on COPRAC this term. I did a term on COPRAC about 20 years ago. 39 years of experience with the mandatory fee arbitration program. I'm currently live in Palm Desert, and I'm not practicing, I'm just doing work as an expert witness in attorney's fees, attorney ethics, and attorney malpractice. And if I wasn't modeling this neckwear, right now I would have been in Easter Island on my way to Antarctica. But so the bonus is, I guess, that A, I still have my head on straight, and B, I'm here at this meeting, and also I was able to stick around and help with my passionate work, which is I'm the attorney coach of the Indio High School mock trial team down here in Palm Desert in the Coachella Valley, which is just a lot of fun working with those kids and watching them kind of get what law is all about. That's a lot of fun. And also being home, I get to water my tomatoes so they don't dry up in the desert heat while I'm gone. So that's me, and happy to be here.
Thanks, Joel. And Bridget, did you want to give a little introduction as well, please?
Sure. My name is Bridget Grammy. I'm the Deputy Chief of Programs here at the bar and work with the Office of Professional Competence. I have a 13 and 15-year-old daughter, so my oldest is just starting high school, and then we had a surprise. So I have a 2-year-old she arrived during the pandemic, who just started preschool. So I too have no hobbies, except I'm from San Diego, and my husband is from LA, and we happen to have tickets to go to the game tomorrow night, which I'm very excited about. So go Padres.
And I think next on the agenda, we're supposed to have an executive director strategic plan presentation.
Oh, actually, Sarah, that's at 11, but can we approve the minutes?
Oh, yeah, sorry, I forgot to get to the minutes. So before we get there, I would like to move to approve the minutes from our last meeting.
And for the new folks, you can just abstain because you weren't at the meeting.
Sorry, guys, can you hear me? I'm trying to make sure my speaker works. This is Eleanor.
Yes.
Are you able to hear me? I think my speaker was not working, so apologies for that. I was trying to chime in there for you.
And Eleanor, I'm sorry, I did not see you on the screen earlier. Did you want to, before we approve the minutes, would you like to give a brief introduction?
Absolutely. Good morning, everyone. My name is Eleanor Mercado. This is my first year on COPRAC. I'm Associate General Counsel at Paul Hastings, and before joining the GC's office there, I was a securities attorney with the firm for about 10 years. My personal tidbit is that my wife and I share 6 children. We have 2 in college now and 2 heading off next year, so we're not quite empty nesters, but the house is getting quieter, and I'm looking forward to having hobbies again. I do have some tomatoes I'm growing with my 9-year-old, and we're always thrilled when we can harvest those before the raccoons do, so I can feel your pain. I'm sorry I couldn't be there in person today, and I really am looking forward to meeting everyone in person next time.
Thanks, Eleanor. So now at the start of each meeting, we generally approve the minutes from the last meeting. So I am going to move to approve the minutes from our September meeting.
Second.
Okay, so I will take the vote to approve the minutes from the September meeting. Sarah Benola,
Yes.
Ken Bacon,
Yes.
Cal Brigham Brown,
Abstain because I wasn't a member.
Elizabeth Bradley,
Yes.
Cassidy Chivers,
Yes.
Brandon Krieger,
Yes.
Joel Mark,
Yes.
Eleanor Mercado,
Yes.
Bill Munoz,
I'll abstain since I was not at the last meeting.
Daniel O'Reilly,
Abstain.
Kyla Rowe,
Yes.
and Hunter Starr.
Abstain.
Okay, the motion passes.
And she seconded it, so I can have it for my records.
Ken Bacon.
Thank you.
So Sarah, the ED presentation doesn't start till 11, so however you want to.
Sure.
That time.
So we're moving ahead of schedule, so I think what I'll do is that, let me just double check the agenda to make sure I'm in order. So I think the proposed amendments to the rules of professional conduct regarding civility through the next in line, and so I can start the discussion on those proposed amendments as a member of the working group and invite comments. We might need perhaps more than a half hour. So what we could do is then kind of take a break to hear the executive director's report and then come back to the proposed amendments perhaps after lunch, or if there's time before lunch. And so I'll give a kind of a general background first, particularly since I know we have 2 new members today, on what we've been working on relating to, and Raquel, did you have a question?
Yeah, I don't want to interrupt you.
No, go ahead.
Could we just check to make sure they can hear us? Because we could hear them, but I'm not sure if they could hear, how they can hear us as we.
That's a good idea.
Start chatting.
We can hear you. You guys are very clear.
Okay, great.
Oh, perfect. Okay.
Sorry, I
So-
will just say, we can't see you though. So if you don't mind, to the extent you can identify yourself before you start speaking, that would help us.
That sounds good, Richard. Thank you. And this is Sarah Vanola, and I am starting to talk about COPRAC's work on evaluating the Civility Task Force's proposed amendments to the rules of professional conduct, which are designed to increase civility in the legal profession. And the Civility Task Force is a joint project of the California Judges Association and the California Lawyers Association. And they developed amendments to multiple rules of professional conduct that they recommended. And at the Board of Trustees meeting, they evaluated many of the Civility Task Force's recommendations, one of which was amending the rules of professional conduct. Another proposal was to have a CLE requirement that mandates civility each year. It wouldn't increase the overall number of CLE hours that an attorney is subject to, but one of those hours would have to be addressed towards civility. The other recommendation of the task force was to require all attorneys on an annual basis to affirm the civility oath, which is already part of the California Rules of Court. I forget the exact language, but it says something to the effect, I will strive to conduct myself with dignity, courtesy, and respect. Because of the date that was passed, I think it was in 2014, if my memory is correct, not all members have taken that oath. So part of it, as part of the renewal process on an annual basis, that's another proposal that's being made by the Civility Task Force. So COPRAC currently is evaluating the proposed amendments to the rules. So that has been assigned to us based on the Board of Trustee meeting. And the working group has worked on evaluating them. We've discussed the proposed amendments at prior COPRAC meetings. And what you have as part of your agenda materials today is a memo summarizing it, our analysis and containing our recommendations. So I'd like to go over that and then see what the COPRAC feels as a group if they approve this memo or have suggested edits before it's submitted to the Board of Trustees. So just as additional background and an overview of our thought process based on our prior COPRAC meetings. It seems that in general, COPRAC is not in favor necessarily of all of the proposed amendments to each of the rules. We think that certain of the amendments don't really fit within the scope of the rules. also that there are some interpretation issues that would cause a lack of clarity. They could be interpreted to interfere with a lawyer's protected litigation activities. And there's also a concern about having different amendments in many different rules that rather than having just one rule that addresses civility, which some members of COPRAC feel it would be stronger to have one rule similar to what we currently have as Rule 8.4.1, which prohibits discrimination and harassment. So that there'd be a similar type rule is what COPRAC is contemplating that would address civility rather than having civility be addressed in both the contents and comments to various other rules where it might dilute the impact. So that's kind of an overview of our thoughts on that. And I'll just start off, and then I'm going to invite others to weigh in from the working group and from the committee as a whole. So the first proposed amendment, and if you're following along with what Angela has on the screen there, what's shown in green highlighting reflects what COPRAC is recommending be changed to the rule, but the red lines themselves appearing are the Civility Task Force's proposed amendments to the current rules. And then what's highlighted in green shows COPRAC's proposed additions, and what's shown in strike through reflects COPRAC's recommended deletions. So as you see with the first rule, that 1.0.1 that contains the definitions, there is now a proposed definition of incivility. And we've discussed this definition at our last meeting. And we have it, this memo does not change what our proposal is, which is to define incivility to mean stiffly unprofessional conduct that is discourteous, abusive, or harassing. COPRAC felt that just defining it as discourteous, abusive, or harassing, or other significantly unprofessional conduct, we felt that other significantly unprofessional conduct was too vague to be enforced as a disciplinary standard. And we wanted to be clearer and more definitive about what conduct would constitute incivility. And then in addition, if you go down a little bit further to the comments to Rule 1.0.1, you'll see a section in green highlighting a proposed new comment 4, which is to clarify that the definition is not intended to apply to conduct that might be protected by the First Amendment, and that the definition includes conduct that would violate an attorney's duties under the State Bar Act provisions. And at the end of each rule, there's a section which is called COPRAC comments, which is really intended to explain COPRAC's analysis and recommendations for the amendments they're suggesting. This one was not as controversial as we discussed it as both a working group and with the committee as a whole. But I'm going to just pause because I don't want to go over every rule. I prefer to have a discussion on each one. So does anyone have any feedback or concerns about suggested edits to the definition of incivility at 1.0.1?
Sarah, I did want to clarify, and this is Hunter Starr. I did want to clarify in that change of significantly unprofessional conduct, you'll note that the change is the types of behaviors now modify and explain what significantly unprofessional conduct is, as opposed to including significantly unprofessional conduct as some other type of conduct that lacks definition. I think that does shore up when lawyers are looking at that, their understanding of what it means. It's not just something that's harassing or something like that, or significantly unprofessional conduct, but rather significantly unprofessional conduct has meaning.
Yeah, that's the threshold. Yeah. It's going to be population.
Okay. And Raquel, did you have a suggestion as well?
Well, this is Raquel, and this is one I've been sort of following the evolution as I was observing the committee. And I do think the further definition is helpful, but I also think it's very, one person's discourteous is another person's, there's not a problem. So I think the more you can drill down and identify what is the behavior, because I think just naming it, I think it's not going to be helpful to someone because they're going to say, obviously, I wasn't discourteous, I was just fill in the blank. So to me, I think that continues to be the area where it's too subjective, still too subjective if you're trying to shape attorney's behavior in a certain way.
This is Cassidy. Do we have examples anywhere in here? I can't remember if we, like what, I mean, perhaps we put in examples of discourteous behavior. I don't know if that's possible, but I don't know, and I can't recall if we've even discussed that as part of the definition. But that might be helpful because that's the tension. I mean, it's always, there is always going to be some level of subjectivity. And I think that's been kind of our struggle with the debate over this. But maybe examples will help, and then coming up with those examples.
It's very challenging. I mean, so I've been on other committees that have tried to contribute to this concept and gotten bogged down in exactly this and kind of throw up their hands. It's very tough. And if there's any group of people that are going to be really creative about ways to get around our examples, we know who they are.
Right.
Yeah.
But I take your point completely, Raquel.
Yeah, we did struggle, as they were mentioning a lot, with the language here, and the language, going back up to make sure, discourteous, abusive, or harassing, that was initially in the Civility Task Force's proposed amendments. And I know they spent a substantial amount of time evaluating what language to use. And as we're going over, and you'll see as we get to the other rules, we tried to, with the other rules, be consistent with the civility oath language, which I'm going off of memory here, but I think it was, someone can correct me, strive to conduct myself with dignity, they use the term courtesy and respect. But I think, so that's another issue to consider. Should we be consistent here in defining incivility? Although abusive or harassing seems to be a higher standard.
Yeah, that's what
And
my instinct was as
discourteous,
well.
yeah,
Is that,
right.
Raquel, how you felt too, that discourteous is more vague while abusive and harassing seems to have a clearer threshold as being, potentially subjecting a lawyer to discipline? Or do you see the same concerns with abusive and harassing?
I think they are on a continuum I chose discourteous, but I also think unprofessional. I mean, it's very subjective what someone thinks it's unprofessional. And I think that tie, when I hear what Erica you said about in your report, in the discipline.
The ad hoc commission.
Right, and the discipline, and that becomes that becomes what happens when it's too subjective. Is that then people apply different standards to different people based on whatever their mindset is. And so the less subjectivity you can take out of it. And so what is discourteous behavior? Like, what is it in this one? What do we think? And maybe that's what we name, not the label of it, but the behavior of it. I don't know. We probably each would go around and say something different, but somewhere in whatever we say would be, that's the bingo.
I have a comment. This is Elizabeth. Justin, I have kind of an issue with that. That what you said resonates with me because abusive or harassing seems to connote some kind of intentional, subjective conduct where that is less, it's easier to objectively kind of look at what's abusive or harassing. It connotes some kind of intent to really be a jerk.
Yeah.
Whereas discourteous, I think, is wide open to include not conduct rising to that threshold, and subjectively, objectively, intentional, non-intentional, anything, and it could be just as simple as not giving an extension, which happens to me all the time. Someone I feel like that is the height of discourtesy. Like, there's no.
Disciplined.
Right.
Right, like,
And it's always like, there's always the like, well, I would, but my client won't let me, like to get out of it. But the abusive or harassing, I think, is more clear, more easy to apply, and less room for vague, interpretations as far as potential exposure to discipline.
yeah,
This is Justin, I share your instinct on that. Discourteous to me is too vague, and the threshold might be too low to say that that subjects someone to discipline, even if it's modified by this significantly unprofessional.
Like
Whereas abusive and harassing, again, I hate to harken back to my soccer refereeing days, but that actually has a very meaningful definition in the soccer world. When you do something that is abusive or harassing, you can get your red card, right? That is just, it's so clear that that's inappropriate. It crosses a bound of all reasonable decency from an objective standard, sort of. Whereas discourteous, to me, I see a difference as well in terms of the scope. And so I think we're still trying to get this out today to the Board of Trustees. And is that right?
Yes.
And so I wonder if we're not able to reach common ground on this, maybe we at least consider flagging in our comments, even just briefly, that we're still struggling with at least some of this diction, including discourteous, maybe connoting a threshold that we don't intend for discipline.
Sure.
This can, I mean, I keep hearkening back to the civility guidelines, which we have already. And on those, I mean, they lay out specific categories, continuances, motions, communications. And then it ends with the attorney's pledge, which is, I will abstain from rude, disruptive, disrespectful, and abusive behavior. So that's the language that's existed in the civility guide. I don't know if that's more definitive than what we're talking about.
So could you repeat that? It's rude, disruptive.
I will abstain from rude, disruptive, disrespectful, and abusive behavior, and will act with dignity, decency, courtesy, and candor with opposing counsel, the courts, and the public. So that's the pledge in the civility guideline. That might be the oath too.
right, but are we intending, so is it the intention to have a violation of the guidelines be a disciplinary offense? I mean, is it, like, we shouldn't be rude, we should be civil and all that, but is there a higher threshold for discipline here that we're trying to get to? Because like what Elizabeth was saying, are we gonna expect discipline if you're going to be not granting a continuance for, an irrational reason that, may be rational to somebody else?
That's, well, from my personal perspective, that's the whole issue with having these in the discipline rules.
I know.
This is Dan. I'm in favor of concluding some kind of a concept of discourteous. I think, to me, there are already rules against abusive and harassing behavior.
That's a good point.
And I don't know what their intent was, but it seemed like usually the incivility exercise is to get at people who are doing this needless, terrible thing, like not giving you an extension or not agreeing to an ex parte schedule or something. It seems like there's a sort of an intent to get that behavior. Not necessarily to make it disciplinary unless it's a pattern.
Right, well, and we talked about pattern, we've gone through the whole pattern discussion. No, I mean, but it is, we keep going back to like the fundamental question, and it's hard to get past it.
Well, I also think that one of the main functions of these rules and the civility guidelines for me has been to go back to my own clients and say, I'm not doing this, that, or the other thing because I live by this code.
Right.
And a lot of times it's client pressure that is pushing this behavior.
I'm in favor of taking out the discourteous. But I mean, if we're going to come to a decision about, I would vote for taking out discourteous because it's too vague, because it's a lower threshold. I think that I don't know if significantly unprofessional conduct can modify discourteous. They're kind of contradictory in a way, because discourteous may not actually be significantly unprofessional conduct, so. I share all the concerns and I would vote to take that out.
Yeah,
I agree.
and I support that as well, but oh, sorry, go ahead, Joel. Is that you?
Yeah, the thing, I agree with taking out discourteous, because I think that what we're looking for is some kind of conduct which does create some kind of material harm within the legal process. And while being discourteous is not a good thing for the profession, if it doesn't cause harm to anybody, just because you don't shake hands with somebody or you don't acknowledge them by their proper address, those are acts of discourtesy, but they don't create any harm. So unless we tie discourteous to some kind of harm to litigants, to the courts or the practice, I think it's just kind of meaningless. I mean, I could be very courteous, but still steal money out of the trust account. And courtesy is not what makes that bad. So I just think we ought to get rid of discourteous. It's just too vague, and it doesn't really materially advance the ball, which is protecting individual litigants from harm.
Yeah, and I understand all the feedback that everyone's raised on that, and I'm in favor of that too. But what I'm questioning is, and this is based on what Dan brought up as well, is there's abusive and harassing. Is there conduct that doesn't necessarily rise to the level of abusive or harassing, but warrants discipline? And is there another term that we could use other than discourteous? And I think that was Civility Task Force's intent in using that term. And I think they were also trying to use a term similar to what's in the civility oath. And some of the examples that I'm just thinking of, the one that was in the recent news in San Diego Superior Court of this unpublished opinion where the attorney used the term, and Cassidy brought this up too, the see you next Tuesday comment. And I think that would fall under abusive or harassing, but I don't know if there's another, should we consider something to replace discourteous, or are we in favor of just taking it out and keeping it abusive or harassing? What do folks think?
This is Hunter. My preference is to remove it. We do run into the problem of, if what they're looking for is, it's a rule to police less than abusive conduct, like discourteous conduct, I think ultimately our stance should be, we shouldn't do that.
Right.
Because there are so many problems with that have been elucidated this morning. One that I'm concerned of, I just wrapped up my 63rd jury trial. When you get into the trenches, these kind of rules can get weaponized very quickly. And that's something that I'm personally, when I read the first draft, I was like, that's scary. So I think that if we're going to decide to set a higher but clearer standard, if the concern is that we're saying, well, we shouldn't police discourtesy, we should set a higher standard, and that's just got to be our position. When it comes to, well, what about discourtesy? That's got to be up to the individual courts to deal with.
Yeah, that's a good point. And I know that the California Lawyers Association submitted some comments on the Civility Task Force's recommendations, including, I don't know if it was this particular rule, but one of their concerns was what you just mentioned, Hunter, which is that the rules could be used potentially not to actually promote civility, but it could actually, that it's intended to promote civility, but it could have the opposite if attorneys are abusing the rules and using it perhaps against younger attorneys or minority attorneys to argue that they're violating the rules that are intended to address civility. So that, I understand that point.
And just jumping off of that exact point, just the other side of it is I wonder what the state bar is inviting with a broad, policing discourtesy. Just in terms of the amount of disciplinary complaints and investigations
Yeah,
that
do
are
we have the capacity?
pour in when there's already enough, very severe violations being reported that it's just an hour's
Oh, it would
staffing
be,
issue.
I mean,
Yeah.
seriously, think about
every trial you've ever had, every unpleasant exchange that could be.
Yeah.
I don't have the discovery dispute.
So I just share the exact same concern, but I would like us to be more civil.
Yeah, I think Erica was about to say something. If you
I
want.
was just gonna reiterate, Sarah, you mentioned this. This is one component of the Civility Task Force recommendations. So as Sarah mentioned, there is the oath that is being explored for all attorneys to who have not taken the oath to affirm that oath, which will say that they'll strive to conduct themselves with dignity, courtesy, and integrity. And there's also the proposal to add the civility requirement as 1 hour of MCLE credit. So some of these things that we were discussing that may not be best suited for a disciplinary rule, such as discourteous behavior, could certainly be something that is provided as an aspect of the MCLE education on behavior to avoid, but not necessarily reaches that higher threshold for discipline.
But how do you teach a CLE to say
What
what's discipline and what's not? I'm thinking about, oh God, my PowerPoints on this would be.
The best practices. See.
Right, yeah, right. But on the oath, I have a question. Like, what does that look like? Is it a card you sign, or do you have to go somewhere and literally take the civility oath? Like, who's taking the civility oath? I mean, we took it when we were.
Would that be a checkbox?
It would be when you renew.
Right, you check a box
So-
and say you.
So it was presented to the Board of Trustees at their September meeting, and there were 3 options presented. One was for all attorneys who did not take the oath with civility language. So anyone who took the oath basically pre-June 2014 would, one option was to go before a public official and retake the oath, like we all did when we were admitted to practice. The middle ground alternative was what was the board was more receptive to, and is what will be presented likely at the November meeting. And that is for attorneys to sign a declaration who have not already taken the oath with the civility language, to sign a declaration. And then annually thereafter, all attorneys would be doing a check the box type requirement to remind them of their the oath they have taken, either when they were admitted, in the more traditional oath format or in their declaration.
Sounds reasonable.
So I'm wondering, should we, since we're likely, I think it seems like the majority of the members who have spoken are in favor of removing the discourteous language from Rule 1.0.1. And I think we could modify the memo to reflect that change and the comments consistent with our discussion at the meeting. But I think maybe we should just take a straw poll, or what would be the best procedure?
That would be fine.
Yeah. So I guess the vote would be, are you in favor of removing discourteous from the proposed amendment to Rule 1.0.1, defining incivility?
And just remove that or add something else, 'cause like Hunter raised, I mean, I think it was Hunter, or no, it's Dan, there's below abusive and harassing, but could still be within the civility issue. So I don't know what that would be, but.
I don't either, but I think a lot of us were talking about maybe that's not appropriate for being part of the disciplinary rules, but could perhaps
I
be
think
addressed
we
through
would-
other means.
I think we would run into the same problem we're having with discourteous. I think it was Elizabeth who said abusive or harassing. I agree that that's like a very intentional, and I'm sure there are gray areas that people could come up with, but I think for the most part, and like Justin said too about like the red flag in soccer, like it's pretty clear from everybody who sees it what is abusive or harassing, whereas something lower than that, the lower you go, as we've seen with discourteous, the more you're kind of getting into a gray area. And I think it sounds like everyone who's spoken agrees that we don't want to create discipline for gray areas where someone's tone or someone's facial expression or someone's, punctuation in an email could suddenly put them in the realm of discourteous, and I think significantly unprofessional conduct. The phrase before abusive or harassing is helpful too. I think that's a good standard too.
Would it, this is Joel, would it help kind of split the baby if we added intentionally discourteous?
Because if I don't say hi to you on the way in, that is intentional.
Right.
But I should be disciplined for it,
Yeah.
right? I mean,
It's not.
I'm
yeah.
a jerk,
What
but
is
I
it?
shouldn't be disciplined for it.
This is Elizabeth. I'm a little wary of removing that concept altogether because of, I agree with Dan. However, at the same time, I feel like if you're looking at what would constitute discourteous, at some point, if that kind of conduct continued or was repetitive or was in a certain circumstance particularly egregious, it would rise to the level, arguably, of being abusive and harassing, even if it wasn't necessarily intentional in quotes, right? So, I mean, in situations that we're thinking about that could fall into the discourteous, the higher level of discourteous, one could still argue that this rises to the level of abusive and harassing on an objective basis of reviewing it, even if there's not any kind of like scienter or subjective intention.
Yeah, Elizabeth, that's a good point, and it's something that I know that when we get to the other rules, the Civility Task Force is not intending that an isolated incident of incivility would lead to discipline. And below, we were struggling with kind of the right language. I think that in some of the other rules where the standards are being incorporated, there's language like repeated incivility, a pattern of incivility. I think there was something else about, oh, Cassidy, you might remember, it was like severe, I think was another.
Severe.
We're
Yeah.
considering language like severe and pervasive, which is used in employment law cases, but we were struggling with the kind of the standard, but I think this is just the definition, but how it's being applied, it wouldn't be applied to an isolated incident of incivility, I guess, unless it rises to such a level that it's falls within the scope of the other rules. So
I have maybe a suggestion. Should we go through the rules and then vote? Just to flesh it out more, to see how it applies, how we've applied it to the rest of the rules?
I think that makes sense. And and so we can consider whether to vote at the end after we go through all the rules about whether to remove discourteous.
Yeah, and as we go through this, I mean, keep in mind, as Justin, keep in mind that we're the rules commenters, we're not the rule drafters for this purpose. So to the extent that we can't in one day come up with the perfect language, but we feel like we should remove discourteous, we can always put in our co-correct comment. We discussed this, we struggled with this, we think that the rule drafters should consider such and such further for whatever reason that we want to provide to them. So we can offer that insight and still get our memo out the door today, if that makes sense.
Yeah.
So I would say I wouldn't necessarily be in favor of removing that phrase, but I would have comments like, just very quickly, what is the effect? It has to have some harm. That's to Joel's point. And that there is some level of conduct that we're trying to address that is less than for us.
And I think there's a reason why we're still struggling with this 100 years after the founding of the bar. It's difficult.
May I interrupt? Our executive director, Leah Wilson, is here for her 11 o'clock presentation. So shall we take a pause?
Yeah, this is a good stopping point. Yes, thanks.
Hi, Leah.
Okay, great. Wow, I was waiting for an hour at the last meeting I was on, so I didn't expect you guys to be so prompt. So I'm Leah Wilson, the State Bar Executive Director, and I appreciate you giving me some airtime today to talk about the State Bar Strategic Plan. This is a new plan adopted. If you could hold on for 1 second, I'm sorry, hold on. Right. The board recently adopted a new 5-year strategic plan, and I'm going to go over the plan with you. But also what I'm going to do is ask you to think of this as fodder for your own work and discussions about the role of COPRAC. And I guess I'll tee this up by saying, I hope that you will consider perhaps a bit of an expanded role or a changed role. And I will give you some examples of what I'm talking about as I go through the plan. So the new strategic plan is organized into 4 goal areas, all of them sort of prefaced by the underlying value that we have, or charge that we have, which is to protect the public. And so you can see the 4 goals listed here. And I'm going to touch on, I think, most of these with you. I'm not going over the entire strategic plan in this presentation because it's quite long, but I'm highlighting those aspects of the plan that I think are most relevant to your work. I do also want you to note that whereas in previous strategic plans, we had diversity, equity, and inclusion as a distinct goal area, in this plan, we have DEI as a foundational principle, meaning it underlines the entirety of the strategic plan. Also of note, when we talk about DEI in the past, it's been very focused on the attorney population, whereas now we are talking not just about increasing the diversity of the licensee population, but also about ourselves as an institutional employer. So that's sort of an important change reflected in this strategic plan. As I said, there are 4 goal areas. Each goal is accompanied by a broad vision statement. So here in goal 1, we're focused on the discipline system. And you can see the vision is that the State Bar discipline system is recognized as, and I think that those are important components, as effective, fair, and timely. The goal areas then are followed by strategies. These are the strategies by which we will implement or try to achieve the goal. The strategies for each of the goal areas are broken into consistent categories: DEI, policy and systems change, effectiveness, and consumer focus. Here in goal 1, I am going to focus on only one of the strategies or sort of tactical strategies outlined in the goal because I'm going to highlight a potential point of intersection with your work. So in goal 1, we talk about the need to develop new case processing standards for the discipline system. I think you all are aware that the State Bar is routinely and historically criticized for the functioning of our discipline system. And part of the basis for that criticism has been the timeliness with which, or the lack of timeliness with which we process discipline cases and backlogs, corresponding backlogs of attorney discipline cases. So the legislature directed the bar to develop new case processing standards for the discipline system. In doing that work, we engaged as subject matter experts. And one of those subject matter experts has recommended a new rule of professional conduct to address respondents' counsel. And so I think for non-attorney members of COPRAC, I'll just say the respondents' counsel is the attorney representing the attorney who is being disciplined or for whom discipline is sought. So a new rule of professional conduct to address respondents' counsel who intentionally delay State Bar disciplinary proceedings. Why this bullet point is highlighted in sort of this maroon color is that this is not, in fact, an activity that's actually outlined in the strategic plan or the operational plan, but rather it's something that has percolated up as we are doing the operational activity that directly ties to your work. And I'm not exactly sure kind of the vehicle for getting this from sort of the subject matter expert to COPRAC, but it's an example of something, again, very related to the work that you do that has come up with respect to kind of an entirely different section of the strategic plan. We're going to move on to goal 2. Here in goal 2, we're talking about increasing access. And again, you see a broad vision statement. All California residents have access to high quality, affordable, and culturally competent legal advice and services. Again, the goal is supported by strategies in the 4 areas that you saw in goal 1. The narrative or verbiage under these strategies changes because here we're primarily talking about admissions and our access work. One of the particular areas of focus in the strategic plan is incentivizing and supporting licensees and law firms to increase the number of pro bono hours. And I highlighted this one for you, not because necessarily there's a connection to your work, but there potentially is. So understanding that a goal of the State Bar Board is to increase the number of pro bono hours, specifically hours provided to underserved groups. Right now, the operational activities that have been identified are these. 1, internally, developing a policy for our own staff to do pro bono work. We don't have one. Tracking the numbers of pro bono hours provided by California attorneys annually. We do not track this. And then identifying strategies for increasing the number of hours. So this is an area, again, where you may not necessarily see a point of intersection because there may necessarily be a rule of professional conduct on this, but I think that you could bring tremendous insight into potential ways that the bar might consider increasing the number of pro bono hours, including, for example, requiring pro bono work. Another strategy under goal 2 is to keep abreast of the legal services market and how changes in the market impact individual consumers. So here there are a number of operational activities that have been identified so far. And on this slide, there's a lot of text here. But you see LRS, these are the lawyer referral services. And there's a great deal of interest in modernizing, revising the rules and the basis upon which the LRS programs are regulated. And I think similarly, we may need to reconsider the rules that apply to lawyers who participate in LRS type of programs. So this, again, a potential point of intersection for COPRAC with the strategic plan. Other related activities, these again in maroon because they are not outlined in the plan as it's currently written, but things that continually or frequently are coming up and where I would love to have your sort of thoughts or guidance or suggestions for the board in terms of how to proceed. And I understand with respect to the first bullet here, cryptocurrency, you are working, I think, on an advisory opinion. Very related is practice in the metaverse. I hope you all are seeing the articles I'm seeing about law firms opening up in the metaverse. We are in California, and I think it would be unfortunate for us not to be out front of some of these issues around the practice of law and sort of alternate universes. And really, speaking to this last bullet, the use of technology in the delivery of legal services. We know that it's rampant. We know it's happening, I think, quite a bit in the corporate legal market. We as a regulator have very little insight or exposure to what is actually going on. And I've also added here ALSPs. It's another area that we hear about, but we don't know much about what is going on. And we don't know, frankly, if there are any current regulatory violations. We don't know if our regulatory scheme should be changed to allow for practices that are currently happening that make sense. We just don't have any insight into this whole area of the practice of law today. And I see COPRAC potentially is very well positioned to dig into these issues and to develop recommendations for the board and the Supreme Court to consider in terms of regulation in these spaces. Another sort of strategy outlined under goal 2 is creating a policy foundation for regulatory reform. And so we just talked, in the previous slide, I mentioned some things that tie to regulatory reform. But here in this slide, you can see my maroon ads. I'm talking specifically about regulatory sandboxes and paraprofessionals and the unauthorized practice of law. So hopefully, I think some of you are familiar with legal regulatory sandboxes. There is an active one underway in Utah, and there is not a sandbox in Arizona, but in Arizona, complete elimination of Rule 5.4. So I kind of put that under the sandbox header. And then in many, many states, we have paraprofessionals being licensed to deliver legal advice. So this obviously requires changes to UPL rules and statutes. These are really important issues and changes going on nationally, in the case of both of these, internationally as well. And again, we don't have a lot of insight into what is going on and what changes we might want to import into the California environment. And so this is another area where I see potential points of intersection between COPRAC and the State Bar Strategic Plan. I'm going to move on to goal 3. Goal 3 is really about regulating the profession. And I want to say here that I think the State Bar has had a bit of a turnaround, I don't know, or going back to where it began with respect to supporting attorneys in the competent practice of law, that being part, core and central to our public protection mission. You know that we separated the trade association aspect of the State Bar from the regulatory arm in 2018. And when we did that, I think we drew a pretty hard line with respect to work that the regulatory agency would and would not do. And I think, unfortunately, that line was a little too far on the, we focus on discipline. We don't focus as much on support for the competent practice of law. With this new strategic plan, you see the board shifting a bit and saying things we do to help attorneys don't make us a trade association. They make us a smart regulator because they will result in reduced interaction with the discipline system. So again, in goal 3, you have the strategies. And if I haven't said it already, I will be sharing this slide deck and I can send it out to you, but I'm not going to read this out loud to you now. And I wanted to focus on, I think I might have 1 or 2 things in this section for you. But here there is a strategy around identifying competency-related factors that drive disparate voluntary departures from the legal profession by race and gender. And right now, what we have as an operational activity is we're going to modify the inactive form to include a survey that's asking questions that try to get at why people are choosing to leave the profession. National data tells us that women, and particularly women of color, disproportionately leave the profession between 8 and 10 years of practice. And there's some anecdotal data about experiences around harassment and bias that people face, practitioners, that will cause them to exit the profession. So based on this survey data that we get, you may see a request for you to consider new rule proposals to kind of address or target issues that are identified. So I wanted to flag this one for you, just to kind of tee that up there. You all know, I think, and have been involved in, I think you provided public comment on some of the rule proposals around the client trust account program. Admittedly, we worked on this rather quickly. I'm going to just show some of the implementing activities here. We worked on the client trust account regulation program rather quickly, and I can imagine that there will be changes needed to the rules. I think you all work specifically on the modifications to Rule 1.4, and I think the comment to 1.15. Hopefully I didn't flip those around. We need to see how those work in action, and we need to be open to and willing to making changes if needed. And similarly, overall with the program, which is the new regulatory responsibility or requirement for all attorneys in California, we may need to modify and make adjustments along the way if we see that something's not quite working as intended. Another related activity, again, not currently outlined in the strategic or operational plan, but something that has been brought up now a number of times, including most recently by the LA Times, is questions around why California has not adopted its own version of Rule 8.3. And this is the rule that requires lawyers to report misconduct by another lawyer. I anticipate that we will be under some pressure to revisit our position on this rule. And obviously, this will fall squarely under the auspices of your committee. Goal 4, I'm going to wrap up by focusing on some of the board's emphasis or values around the operations of committees themselves. This is not COPRAC specific. And when I give these presentations to any of our sub-entities, I'm going over some of these items in this last set of slides here, because I want you to understand how important it is for the board to have the state bar kind of lean in to transparency as part of our effort to restore our credibility, our reputation, and our impact. You see it written there in the goal statement. And so as part of that, there's some work underway that's going to impact all of the sub-entities that I want you to be aware of. So the first is to enhance the visibility and accessibility of state bar meetings, okay? And what does that look like? So you know that most of your meetings now will be remote, and then you will have 2 in-person meetings a year. And those in-person meetings will actually be hybrid meetings because both members of the committee and members of the public can participate by Zoom. We are actively monitoring what other, particularly government agencies, are doing in terms of both fully remote and hybrid meetings. And we will be developing guidelines for how meetings should be conducted. And so, for example, are we going to be requiring things like cameras being on for members of committees? Are we going to have standardized processes for taking public comment at meetings, the duration of the public comment, whether or not public comment can be curtailed? All of those types of things, you should expect to start seeing guidelines coming out. And I should say stronger than guidelines. It is my expectation that staff to each of our sub-entities will be implementing these policies as they are adopted. And we should have some expectation that they will change and evolve, because the intention is to reflect best practices in the administration of meetings. Another aspect of Goal 4 that I want to highlight, that I'm personally really excited about, it has to do with the state bar as an incubator for innovation. That we are charged with sharing our successes and best practices. It's not all about failings of the discipline system after all. And so here, as an operational activity, sort of going the level below the strategy, I wanted to highlight our 100th anniversary. The state bar will be turning 100 at the terminus of the current strategic plan, 2027. We will begin active planning for our 100th anniversary late 2024, early 2025. But in advance of that, I'd really like you, and particularly those of you that have been around and working in the bar for some time or with the bar, to start thinking about both the accomplishments of this particular committee that you are most proud of, work that you think we should be highlighting and elevating as part of that 100th anniversary. And it may be work that is yet to come, things you are working on now. But I just want to kind of tee that up for you as something a concrete ask as you're doing your work and planning in the next couple months or year or so. Demonstrate transparency. So I mentioned this sort of in the opening to Goal 4. The board is absolutely committed to demonstrating transparency, and you will see this in a number of ways, including our proactive provision of information. Most recently, some of you may know that we changed our position in pending litigation with the Los Angeles Times, and really called out this commitment to transparency as part of the basis for our changing our position. So you will see it in the proactive release of information. You will see it in the reactive response to inquiries. You'll also see a push to not just be transparent about the outcome or the decision, but also the why. And so as you're doing your own work, I'd just like you to keep in mind that the board is very serious about being transparent. And so to whatever extent that's relevant to the work that you do, I'd like to encourage you to lean into that concept of transparency. Another one here that doesn't require too much explanation is expansion of multilingual content and outreach. You will see this, you'll see an expectation that for all of our sub-entities as well, that we are really being intentional about communicating, particularly in the top 6 languages in use in California. Increasing the number and variety of stakeholders that are engaged with the state bar. So this is an area that I'd like each of you to think about based on, the role you have, not really on CoPrac, but the roles you have in the rest of your life, and thinking about, is the state bar kind of maximizing its engagement with potential stakeholders? And this is thinking not just of our traditional partners, but also those non-legal services-based organizations that may be interested in the work that we are doing, that may be an important voice to weigh in on the work that we are doing. So this is an important part of Goal 4, kind of expanding the network of partnerships that the state bar engages in order to increase the voices coming into the bar. And that ties right into the next strategy. And this is the last one I'm going to go over with you, but engaging diverse voices in the development and evaluation of state bar policy. So I mentioned kind of increasing partnerships as one prong of this work, but another one here, and I wanted to put up these operational activities. You see at the top 2 are ones that I want to focus on with you. Expand outreach for sub-entity appointments to support the long-range goal of diversifying the membership. And here I am not just talking about, although it is critically important to have a racially and ethnically diverse and gender diverse set of members of our various state bar sub-entities, but I'm also talking about public members in particular. This Board of Trustees is very focused on the percentage of public members on our various sub-entities. And you should not be surprised to see a push towards more public members on all of our sub-entities. And so, really just wanting to tee that up for you. Also related in a different way is the second bullet around the public comment process. So when we talk about engaging diverse voices in state bar policymaking, part of that is who's on the sub-entities that recommend policy. Part of it is what are the organizational partnerships that the state bar is engaged in to help inform policy. But part of it is how do we solicit public comment on various proposals being considered by the organization. You may know that historically we have we've engaged in a process that I would not call accessible. Our process has been to put out things for public comment. They're often very dense documents, many pages, and with a lot of legalese. We also have historically sent things for public comment to our licensees or to people who sign up to receive public comment. We have not done a good job of proactively reaching out to the true public to solicit public comment. I would say in the last year, this has changed. We've done it for some important proposals. We have one of these types of sort of more modern public comment processes underway right now with respect to the recommendations of the ad hoc commission on the discipline system. But you will see more and more push and focus on use of plain language in the public comment process and truly trying to hear the public voice. So with that, I'm going to stop sharing. I've kind of gone over the strategic plan. I hope I've given you some ideas of potential points of intersection or areas of study for COPRAC with respect to that plan or advancing the ideas articulated in the plan. And then wanted to close out with that overview of sort of where the bar is going with respect to its sub-entities. So I'll pause there. Thanks for bearing with me and happy to hear any questions or reactions.
Thank you.
We're absorbing.
We are. No, this is very helpful. And I think this will help when we, facilitate this discussion and our other meetings and considering these points that you've made. So we'll make an effort to make sure we incorporate the points, which are all very useful points. So thank you for presenting this strategic plan.
Okay, great. And I will get the deck to staff to share with all of you.
Thank you.
Thank you.
All right. Thank you all. Bye-bye.
A bio break. That's what I was thinking. Lunch is here. Is it here? Should we do lunch early?
I just know that people want to sit for an hour.
Yeah. I think a lot of us got up super early. Maybe that's.
So what's going
I'm
on?
hungry.
We're taking a 5-minute break right now, and then
Lunch.
we're gonna decide on lunch when we return from that break.
Yeah. I'll wait till more people.
Maybe we should see what the lunch is, and that might inform our decision. So when we want to eat it,
All these meetings.
it's going to inform my decision.
Hey, Mimi,
Yo, yeah.
should I pause this or let it roll?
Okay. Thanks. And I know everyone's tired. Early morning trips, or many of us are, but I think we should try to move forward for maybe just maybe a half hour before we take our lunch break, because I saw the lunch here is sandwiches, so I think they'll say okay. And since I think the civility proposed amendments to the rules will take some time. So I'd like to move forward with that. And I'd like to move on to the next rule, because I think we spent a lot of time talking about the definition of incivility in 1.0.1. And we'll come back to that at the end after we go through everything else about, our concern about discourteous. But I'd like to start with, I think we can at least get through one or potentially two additional rules before the lunch break. And so the next proposed amendment to the rules of professional conduct that the Civility Task Force recommended revising is Rule 1.2, which addresses the scope of the representation and allocation of authority between the attorney and client. And as you can see through the from the red line here, Civility Task Force recommended that there be an amendment to the substance of the rules subsection A, which would have stated a lawyer does not violate this rule by acceding to the requests of opposing counsel that do not prejudice the rights of the client, being punctual and fulfilling all professional commitments, avoiding offensive tactics, and treating with courtesy and consideration all persons involved in the legal process. COPRAC discussed that amendment and believed that that language wasn't appropriate as a disciplinary standard. It's provides helpful guidance for lawyers, but really isn't a disciplinary type of standard. So our COPRAC's proposal was to move some of that language to comment 1, and comment 1 is addressing paragraph A, which is actions that the lawyer is authorized to take on behalf of the client, such as in procedural matters or making certain tactical decisions, and versus action that the lawyer needs the client's consent for. And one of the, so as you can see by the green highlighting here, the language was incorporated here for Civility Task Force, but modified to provide kind of an example and to track the language of the rule, instead of saying a lawyer does not violate this rule by saying a lawyer is authorized to accede to And we modified requests of opposing counsel to add the word reasonable to modify requests. And adding that term reasonable, we thought was appropriate, and also it's consistent with equivalent versions of similar rules. And you can see that in our COPRAC comments, where we've cited to some other states, Massachusetts and Michigan, who have similar language and refer to reasonable requests of opposing counsel. So the comment now reads that a lawyer is authorized to accede to reasonable requests of opposing counsel that do not prejudice the rights of the client. I don't think we had the other change to the Civility Task Force's proposed language is they had used the term treating with courtesy and consideration all persons involved in the legal process. And COPRAC thought it was more appropriate to use the language from the civility rule that I've been talking about previously, which is dignity, courtesy, and integrity. So I will pause here, but we think that this does provide helpful guidance and an example in a comment, but it isn't appropriate for a disciplinary standard. So that's why we propose to move it to a comment. So do others have feedback or recommendations relating to this proposed amendment?
Yes, Stan, I like the approach of taking something out of the rule and putting it into the notes. I feel like that addresses what a lot of people have concerns about, which is the possibility that this becomes weaponized. And I think you can still point to the comments and as authority if you need, back and forth with opposing counsel, for example. But it doesn't make it something that somebody is likely against you.
And I think this comment could potentially be used, Elizabeth, that example you gave in terms of, opposing counsel not agreeing to reasonable requests for extensions of time. Not that that's a disciplinary issue, although I know that comes up a lot, and I think it's the Rudder Guide on professional responsibility has a section on that where they're interpreting this rule 1.2 and say that they provide that as an example of something where the lawyer is authorized to accede to a reasonable request of opposing counsel. You don't need your client consent unless it's something like a summary judgment motion, perhaps, or something that's more substantive, just like a discovery matter. But do others have thoughts on this one? This one, I think that the ones that follow will, I think, warrant a little bit more discussion. This one, at least the prior discussion, we didn't have a lengthy discussion on this particular rule.
Sarah, I think that, as Justin noted earlier, we're just commenting and sending it back. I think that we may want to point out that this is probably a more helpful approach, which is let attorneys know which rules they're not violating by being civil, as opposed to trying to mandate civility through rules. I think that's probably going to be more helpful to attorneys, especially when they're getting pressure from their clients.
Sorry, I'm just jotting that down because I think that's a good point. And I think, actually, Angela, I'm not looking at the screen at the same time.
Mm-hmm.
Angela's also doing that, so I probably don't need to, but I think that's a good point, and we can try to incorporate that into our comments here in the memo. All right, so I think, does anyone else have anything they want to raise? If not, I think maybe we'll talk about the proposed amendment to Rule 1.3.
Yeah, very much, Erica, a very minor thing. I think you're missing a bit of parallel structure in the sentence with the change from acceding to accede. It's accede and then it's being treating.
When the recommendations are made.
think we're getting there.
That's the other.
Okay.
Share with us.
There was a lot of commentary.
That's the peanut gallery.
What is that? Is that what meeting is that? Like bar examiners? A lot of, that one's a much more lively meeting.
Oh, yeah, I see.
Is that what all the beeping was, or was that you guys?
It was not us.
Sure.
Hold on for just, but that explains, the public or those attending on Zoom, we're gonna be able to
Can we mute that somehow? I would say that's very helpful conversation.
I don't think this would work.
Should we maybe break for lunch then?
Yeah, that makes sense.
Fine.
All right.
Yeah.
Oh.
Just
that bad.
Okay,
All right.
Mimi, are you still able to hear us?
Yeah, well, not, yes, I can still hear you.
Now we can. That was cacophonous.
Yeah, there was, apologies, there was feedback from another meeting. Can you hear, Sarah, do you mind saying, can you?
Yeah,
Can I hear you?
Mimi and everyone, can you hear me?
Yes.
Sarah? Okay. So just to go back to Erica's point, and I see what she means. Right now, it's saying a lawyer is authorized to accede to reasonable requests of opposing counsel that do not prejudice the rights of the client, and being punctual and treating all persons. That needs to be modified. I think it should say.
Could it just be such as being punctual? That's an example of something that does not.
Christina is on here and is in the room.
Yeah.
That's the
I'm trying
audio.
to figure it out. With Joe is there, my team in the room, but
So they're having the same issues.
Someone. Yeah, that's
I
not.
don't understand how they're saying that. I can see them.
These are different meetings. So that audio is that.
That's what I was thinking. It's kind of awkward.
More technically challenging.
It's far multiverse.
So maybe to be in the tree. Because I don't think such a.
Maybe we should go back to the Zoom. They never had that technical.
You can't do an ING for seating.
Yeah,
And
that's
how
because
we
they're
phrase
messing with
it.
the
So it's
control
gonna be
pad in
two
LA,
seats.
so they're trying to see why they're keep trying to get us back, but I don't.
Okay.
I'm no IT person, but I don't know that that's gonna help. But
I have no.
Yeah.
Yeah, so
Okay, so
that's
this-
the-
I just don't know if we can tell the people
Audio
on
from
Zoom we're gonna
another
do that.
meeting that's coming in.
It
Not.
sounded like-
Chat.
Put it in the chat.
Yeah.
It sounded like they said, because they said in LA,
Right,
so
there's
maybe
some
they're in San Francisco.
Yeah.
They said somebody in LA was messing around with the control panel. That's whoever was talking. So
They can
They're
hear
not
us.
that sounded like they were elsewhere. I'm guess would be San Francisco.
I think, okay. Mimi, can you hear us and no one else at this point other than this room?
Yeah.
Okay.
Are you having a party in San Francisco or?
And you didn't invite us?
Okay, I think we're,
All right, well, let's try for a third, and if it happens again, we'll break for lunch. That's the plan. So I think we were just talking, I don't know that such as works here because it's not an example of acceding to reasonable requests of opposing counsel. So I think we might have to do to be punctual and to treat all persons. I think it's somewhat awkward, though. I don't know if that's the best way to.
Punctually fulfilling.
But right now it's saying a lawyer is authorized to accede to.
So it's two, right.
what about just be?
Yeah, about
Be punctual.
be punctual.
Yeah,
Yeah, that's what, oh, rather than to be.
Yeah.
Yeah, you're right. To
And then
be punctual.
and then treat.
Treat, yeah.
To be punctual.
To exceed, to be punctual. So it's like to exceed, to be punctual.
Yeah.
Right,
To
and
treat,
to be
treat.
punctual.
To be punctual.
Well, because you have the two at
Oh,
the
you already
beginning,
have the two, so you
modifying.
could just say be punctual.
Person. I know.
It makes everything in the infinitive, so that's.
And so instead of treating all persons, it'll be treat all persons.
Right.
And avoiding would become avoid, right?
Correct.
What if we just put the accede to reasonable request at the end? That I think it might read a little better that way.
How would you? How would you
I
say
see
the
that
first
makes
word?
If I'm following it, we're saying that being punctual, et cetera, is not about acceding to reasonable requests, right? That's independent. Is that correct? So you could say, for example, a lawyer is authorized to be punctual in filing all professional commitment, or in fulfilling all professional, avoiding offensive tactics, treating persons, et cetera, and acceding to requests of opposing counsel.
I think if you just get rid of the ing on avoiding, you're okay.
Authorized to accede, to be, to avoid, to treat.
Right.
Yeah, exactly.
Okay.
I don't know if I like the word punctual there.
John, lawyer is authorized to be punctual.
Sometimes
Seems obvious.
You
Yeah.
know, things it's weird is that we're authorizing them to be punctual. It's like what?
Yeah.
Like, really? I authorize you to treat all persons involved and with dignity. I mean, really? I think they might need to be two separate thoughts or something.
Yeah, it is a little strange.
Yeah.
Punctual. Yeah,
I'm
that just-
allowing you to be punctual. Really?
Or are we
Fulfill all
thinking-
professional commitments in a timely fashion.
You know, I'm wondering,
Right?
although
Like that
we
better.
initially proposed this amendment to try to track an example of what a lawyer is authorized to do, I think that it might have been better the way it was worded to begin with, where a lawyer does not violate this rule by, but still having for example, I think, because then it's an example of kind of within the scope of this comment, but I think, for example, as we discuss this as a full committee again, I'm leaning in favor of not making the change COPRAC initially made, to use the language authorized to, and instead saying does not violate this rule by. But what do others
So we're
think?
going, okay,
Yeah.
so we're going back.
I agree.
we're going-
I like that.
We changed it to just, I mean, I'm not saying I disagree, but we changed it to authorized to act, I think to be consistent with the preceding sentence, which talks about authorized to act.
Yeah,
And then instead of flipping from a positive to a negative, I think that was the concern, just to
yeah.
frame it.
I think it gives more guidance if it's stated in the affirmative, meaning this is what you are able to do versus the non-assumption.
Yeah, and that was our initial, as Justin mentioned, our thought process. It is kind of awkward as
I agree.
Cassidy is pointing out, to say you're authorized to be punctual and you're authorized
Well,
to.
Sorry,
Why
this
don't
is
we
Dan.
change it to may instead of authorized?
Yeah, this is Joel. This is Joel. I was wondering about the word authorized. Who authorizes? Why isn't it permitted? Or
That's
it
where
is
we're
not
at.
permissible, or
Yeah,
it is
may is
Or
permitted.
may, a lawyer may accede to reasonable requests. Be punctual in fulfilling and treat all persons. So, I don't know.
But
every-
you're, sorry,
May suggest the alternative.
right, what you may, because the end of the sentence is you may do this and this and this without violating the rule, which is basically saying a lawyer does not violate this rule by doing this and this and this, so.
And the authorized language is, I mean, the reason we initially COPRAC had that is because it's in the comment already, that language authorized. A lawyer
It's
is
not-
not authorized, follows this sentence, or this proposed addition, so.
Now I like does not violate.
It may seem
Well-
strange that we talk about they're being authorized to be punctual, but I mean, I guess there are situations that you could think of where somebody would be intentionally late in order to gain some kind of advantage or to put pressure on somebody. So I think, for instance, like showing up late to a negotiation when you know the other side's going to be in a time crunch. I don't know, I think changing definitive and leaving it is fine.
Or the alternative, why not just get rid of that
Yeah.
being punctual in fulfilling all professional commitments? Get rid of that phrase right there.
But when you read them together, though, that preceding sentence, a lawyer is authorized, that's what we were concerned about last time, to act on behalf of the client, procedural, and then it says, we're overlooking the for example. Since it says, for example, it seems like we could take out the second lawyer is authorized. And say, for example,
Right.
lawyer may exceed, may.
Yeah, because we're talking about scope of authority and that's where authorized comes
Right.
from. Yeah.
Also, if it's important to follow up on the first use of the word authorized, then instead of just removing it, you could also say, this general authorizations include acceding to reasonable requests, et cetera, et cetera.
Or the lawyer's scope of our authority.
I think you could take authorized out because it is an example of for the previous sentence. That would be probably.
So, Ken, you're proposing, so, and I think Mimi suggested this as well, is, for example, a lawyer may accede. That seems to work.
Yeah.
I know a few members agreed to that language. Does anyone have any concerns with changing it from authorized to may?
I like me.
Yeah, in the context of the whole paragraph, it makes the most sense.
And just, accede kind of bother, why not just say agree?
And I don't like punctual either. Sorry.
I mean,
we could
accede
say-
sounds like
well,
they're making some great concession or.
If we're being consistent with the play out of the state bar, we should use plain language. So I think we should use agree.
Yeah.
Because I think that is more, that is clearer.
Yes.
They actually appear in another rule somewhere, agreed to reasonable requests for blah, blah, blah. Or may provide, no. No luck.
Agreed.
I think
That's a more
agreed's
civil
proper.
way of stating it.
Yeah,
What, do we want to address what we do when the client says, I know you may do these things, but don't do it?
Is it
That's
stronger than a may? Is it required?
No.
The first
It's a
sentence.
Not
sentence.
required.
Yeah, the
Previous
prior
But
sentence.
it's an example of with something that's in the scope of the attorney's authorization. So I think in that situation, the client can't decide what the lawyer
Should be.
does.
Right.
Can't, the client
But
Should we-
I've
control
seen
and direct you to do this.
situations where, not in the discipline, but in court. I represented a client who got called in on an OSC. Oh.
Which is fairly recent.
For-
They don't.
The client said, don't grant this extension, so the lawyer didn't and got called in on an OSC by the judge.
Well, I get those questions all the time from lawyers. My client wants me to do all, in fact, I just had this last week. My client wants me to file this ridiculous thing, do this, and I said, those are tactical decisions. Those are things that fall with your scope of authority. But at the end of the day, you have to withdraw and you just simply cannot. So do we address all of that?
Because I think we're
Oh, our meeting is going to
Yes.
pause to figure out technical difficulties.
A lot of pageantry.
Do you want to set a time to read?
Yeah.
12:30.
Annual percent.
Well, I was thinking we were going to take a lunch break. Since we usually only take an hour, can we pause? I think we should take a break until, you want to do it shorter? 12:45? Return?
Until 12:45.
They appear to
Yeah,
be
so
much
CoProc will
more-
reconvene at 12:45 and then we
Obviously,
can.
obviously, much more contained.
Can
and
we go somewhere else?
organized what-
Oh,
like,
this is-
because they-
No, you're captain, you have to stay.
No, but I mean, can we go to a different room? I'm like,
Undercurrent,
Oh, I'm sure.
sarcasm, et cetera, et
How do we
cetera.
flee the audio?
And
Takes
everyone,
a
the
while
lunches
for
are out on
Rick
this
to catch
table
on.
out here, I believe. The meeting. All right, so I understand that due to some of the technical issues we've been having today, as well as maybe a Zoom link issue, that some members of the public may not have been able to join at the outset of the meeting. And so I just wanted to double check if there are any members of the public who would like to make a public comment at this time before we proceed with the meeting.
Please use the raise hand function if you're a member of the public and would like to give a public comment right now. I don't see anybody.
Okay. So then I think we can get back to going over the proposed amendments to the rules of professional conduct to address civility. And before the break, I think we had completed our discussion of the proposed amendments to Rule 1.2. So I want to start with the proposed amendments to Rule 1.3. And the Civility Task Force recommended a new comment 3 be added that you can see in the red line, which it's hard to read with the red line, but essentially it said a lawyer's duty to act with reasonable diligence does not eliminate a lawyer's other professional obligations, and lawyers should strive to seek to treat all persons involved in the legal process with courtesy and integrity. So as an initial matter, COPRAC and the subgroup discussed that we felt that this doesn't really fit within the scope of this rule, which is dealing with the lawyer's diligence in representing a client. So our initial proposal is that we weren't in favor of this particular amendment. And instead, the board should consider moving this provision to either Rule 8.4, which we'll be discussing later, dealing with misconduct, or incorporating as part of a standalone civility rule, this type of provision. But we didn't think it really fit within the scope of Rule 1.3. So that was our primary recommendation. However, we did, in the event the board disagreed, we offered some suggested edits that we thought helped to clarify and remove some ambiguity in the proposed language. One was just consistent with what I've been saying previously, is using parallel language from the Civility California rule of court, dignity, courtesy, and integrity, as opposed to, I think previously it's hard to tell, but I think it was courtesy and integrity, and it looks like we redline respect. And then we also, the language strive to seek, we thought was very vague and unclear. So we thought we should be more straightforward and direct and just say should treat all persons. So I think those are the two key. And in addition, we remove the language duty to act with reasonable diligence does not eliminate a lawyer's other professional obligations and lawyers. We didn't feel like that language added much value or was appropriate as part of a disciplinary rule. So that's why we proposed to strike that language. So I guess what I'd like to hear from members, I know we talked about this previously, is just, do you agree with the proposal that not to make this amendment at all to Rule 1.3, given that the reasons I've already explained?
Yes.
Yes. Yeah. Okay, so it seems like what we were saying in our comments is consistent then, and that we're in agreement. And I think we discussed this at our last meeting, but we're kind of doing alternative proposals just because we don't know what direction the board will go in, so they have some alternatives to consider, and also just frankly, given the time we've had to consider these proposed amendments, and not really a time to fully vote on every minor edit, and so we're trying to present options. So I think, does anyone else have feedback they want to talk about this rule, or should we move on to the next one? Since it seems like we're not.
I just have a question.
Sure.
What are you saying? The whole rule comes out?
Not the, sorry, I wasn't really clear, but I meant the proposed amendment, which is just the addition of comment 3.
Okay.
That, based on our prior discussions, I understand that COPRAC is not in favor of that proposed amendment to Rule 1.3. We wouldn't propose striking the rule altogether.
So
Just-
the rule in A and B would remain.
Yes, and comments 1 and 2 would remain.
Thank you.
The original language didn't really compute. I don't know how people would be citing diligence as a reason to not comply with some other obligation. So I think, I mean,
Yeah.
it's strict, but I understand their original.
Yeah.
I think the concern, this is Hunter, I think the concern is that anytime an attorney seeks to use the rules as an excuse to act in an uncivil way, this is making sure they can't do that. I think that's the intention behind this.
Right, it's similar to the last rule, which is, diligence doesn't mean like railroad everybody in your way, or, so, but it's, the comment is more like a reminder to be nice, I guess. So I don't know how much teeth it actually has other than to be that reminder.
Which is why it really belongs in the comment as opposed to
Right.
the substance.
Right, that's why I'm not really offended by it, like I think that it's, but it, yeah.
And I think Joel pointed out at the last meeting, if you look at Rule 1.3A, it's talking about diligence in representing a client. And this doesn't really fall within diligence in representing a client, which I think we all tend to agree on. So I'm going to move on because I know we don't have a lot of time, and we on to the next set of rules, which is 3.3 to 3.5. And just as we go through these, I think just one overarching comment is COPRAC, based on our prior meetings and meetings of the subgroup, believe that a lot of these proposed revisions to 3.3 to 3.5 better fit in Rule 8.4 or a standalone rule. But to the extent they remain, we are recommending suggested edits to the rules. So the first one, and similar to the diligence, I think many of the members believe that some of these proposed amendments don't fall within the scope of the rule. So Rule 3.3 is dealing with candor or towards the tribunal, and Civility Task Force proposed to add subsection E, which, as you can see from the screen, initially said, in a period before a tribunal, lawyers shall not, and then there's 3 subsections: engage in a pattern of incivility, intentionally or habitually violate any established real procedure of evidence, or engage in conduct intended to disrupt the tribunal. And after considering those 3 parts of new subsection E, proposed new subsection E, the committee as a whole felt that the only language that would be appropriate for consideration as a disciplinary rule would be the 3rd subsection, engage in conduct intended to disrupt the tribunal. And we also felt that adding the modifier solely intended is appropriate to avoid interfering with the lawyer's protected litigation activities. And if you go, we moved some of the information that we struck from the substance of the rule. We proposed moving that to new comment 10. And I'm not going to go into too much detail with this because we went over a lot of this at our prior meetings, and I know we don't have a lot of time. But although this is appearing in green, some of it was simply moved from the other proposals. I know we struggled with some of the language, habitually, which Hunter brought up has a established meaning in the criminal context, and we decided to use repeatedly. And a lot of this is explained in the COPRAC comment section, but I'm going to just open this up for discussion. But because our ultimate recommendation is to just not make this amendment to Rule 3.3, I don't know if we want to get into a lot of detail about the red lines, but I'll pause and open it up for discussion.
This is Hunter. I did want to point out, and I'm sure everybody's noticing, that some of these changes are going to rules that don't necessarily make sense. We just looked at one of those. We're talking about candor towards the tribunal. And candor, while it has plenty of nuance to it, generally isn't about decorum. And so I think that's one of the reasons why we decided to go with putting this into 8.4 is just makes more sense regarding context.
I just did a search for incivility through all of the, with our red lines, we're not even using the word incivility in any of the rules. So we're defining it, and it's not even part of any of the rules. I think there's in there in the they're in the comment here where it's the pattern of incivility, which sort of makes sense because like what we were talking about the definition before, you know, you can have a pattern of harassing behavior and whatever. But where are we going to use the term incivility if we're going to, you know, craft a rule around it? So that's my only comment there. And I agree with Hunter and what we've said in the past that it just makes no sense to put the incivility rule, whether it's actually the word into this series of rules 3.3 to 3.5.
I have one other comment that's more general. The word solely comes up a lot, and I know it's a solution to a particular problem, but sometimes to me it creates an empty set because nothing is solely intended to do the wrong thing. I'm trying to win. I'm trying to discredit a client, credibility. I'm trying to represent my client. If it happens to do the other thing as well, then so be it. But solely is a tricky. I know the problem it's trying to solve, but it kind of creates an empty set.
I struggled over that. Like, you're picking up on all the stuff that we
Right. So
No. I mean, it's a continuing struggle, and it's
Yeah,
good that you're.
And that's why it's hard. That's another reason why we just don't think some of this is really appropriate as a disciplinary standard.
That's
because it really poses a lot of issues of interpretation.
once you
and
put solely, you can
subjectivity.
drive a truck through it. And I'm not doing anything solely for any particular reason.
Yeah.
You know.
Right.
This is Elizabeth. I think, it spurs the conversations of, okay, what's the one defensible reason we can have for taking this action or doing this thing or filing this pleading, knowing that that's not why we're doing the motivator.
Representing my client.
Yes.
That's a valid
Zealous
reason.
advocacy.
Zealous advocacy.
I mean, I think our use of solely is intended to create what some would say is a high bar, and you might say is an impossible bar to prove because it's like you say, it's sort of this null set, but at the same time, I think that's kind of our point, and we don't have a perfect solution for it. But like if if a lawyer's throwing chairs in the courtroom, maybe that's solely intended to disrupt. I mean, like that's the kind of bar that I think we're trying to set here. You know what I mean? We just don't know the perfect diction, I guess.
Yeah,
It's hard to find that.
However, he may be demonstrating what happened in the bar fight.
Right,
That's right. So this is yeah.
Right, like the dog. Remember the prosecutor who like got on the dog attack trial in San Francisco years ago, where she got on the floor and was it was like outrageous behavior, but she was being a zealous advocate.
I think it is a demonstration that these are probably not great.
And that's what our struggle is.
Yeah, they're great notes, comments. Some
In the off chance that we have an attorney who is, they're just beyond the pale. It does provide some teeth that the judge can go to. That being said, anytime you have arguably dual purposes, it does have a chilling effect on advocacy, and that's what we're trying to do.
Right.
And that should be, in that situation, it should be left to the trial judge. That he or she would be the best person to know, is this sanctionable conduct? If the trial judge is saying no, then Office of Trial Counsel should not be touching it. And so I think we'll leave it to the trial judge. Because otherwise,
And part of the concern that we have in this idea of chilling advocacy, zealous advocacy, is that these rules are designed to protect clients and the public. It's not designed to, I mean, it's designed to protect clients and the public and the profession, but at some point, we can't be hurting ourselves in the exact same mission by chilling that advocacy so that when your client expects you to make the argument or to stand up and raise your voice, you say, well, I don't want the judge to frown at me for that. There's this rule. So I think that we run into a problem where we're potentially sabotaging our own mission.
Yeah, and I understand what you're saying, Hunter. Just the one counter to that, just because I know this is something that was raised in the Civility Task Force report as well, is that ultimately incivility, and I don't agree that we should make this amendment, but ultimately incivility harms the public and harms the clients, right? They might end up paying more expensive legal fees because of petty fights going on between counsel. There's a lot of other examples of harm that the task force, set forth in its report. And I'm blanking on some, but that was one example they provided. So
That's what fee arbitration.
I mean, I think that racking up fees is one of the motivations for a lot of this that make, especially when it's David versus Goliath. It's the whole point.
Delay and.
Yeah, I mean, I think there's just a better way to address it. I mean, the more we look at this 3.3 whatever series of rules, the more I think it really does not fit here. And I can't think of a really good reason, like a devil's advocate reason to say that it should be in a separate rule. So if anybody has, a reason why they should fit this, the civility rule into candor, I can't think of one. I can't think of a good reason for it.
Well, one question that also comes to mind is why the discipline rules are the focus? Why not the rules of civil procedure, for example, or other judge-controlled devices? Judges already have a lot of ability to control the courtroom, but I could imagine some of these things being in amendments to the rules of civil procedure.
Or local rules of court.
Civility rules.
Local rules.
Yeah, which are probably, I don't know
the,
how.
the local rules do address some of this. I mean, not, some of the.
Not throwing chairs necessarily.
And courts have cited to the local civility rules and the state bar civility guidelines and published opinions, including in the civility oath itself. I've seen that, not much, but it might be unpublished cases, but there have been a couple of cases I've come across when I was looking into this a while ago for a civility presentation where courts have cited to the civility, reminded attorneys about their civility oath as part of the opinion.
Right.
Okay, so I think we generally are in agreement. I'm going to just go through 3.4 and 3.5, but basically, I think based on our prior discussions, COPRAC recommends that instead of making the Civility Task Force's proposed amendments to rules 3.4 and 3.5, that they instead perhaps be incorporated as part of rule 8.4 or not made at all because they wouldn't be appropriate standards for discipline. So 3.4 is dealing with fairness to opposing party and counsel. And the Civility Task Force recommended the addition of subsection F, which initially read, a lawyer shall not ask any question intended to degrade a witness or other person, except where the lawyer reasonably believes the question will lead to relevant and admissible evidence. And COPRAC, again, to the extent that the board considers this proposed amendment, COPRAC recommended that it be revised as shown on the screen. And because we don't think it was limited to asking a question. So we changed it to engage in conduct. And again, use that term solely, which I understand we've talked about being problematic, solely intended to degrade a witness. And for similar reasons, because we were just concerned about chilling legitimate advocacy on behalf of the client. And I think And also we also proposed the addition of comment 3, which I should, maybe Angela, if you could scroll down. Paragraph 3 was kind of expanding on that point, that it doesn't apply to impeaching a witness, developing theories. It provides examples where the question seeks relevant information that's reasonably calculated to lead to this discovery of admissible evidence. So we tried to make clear that this language is intended to be narrow to avoid interference with the attorney's duties as well as advocacy. So I don't know that, but I think our ultimate, and this was presented in the beginning of this memo and as part of Rule 3.3 comments, our ultimate recommendation is that this amendment not be made. But if it is considered, we propose these changes. So I'll open this up for discussion now.
The only kind of difference I see with this one and 3.3 is that it would apply to depositions, where the civility rule really does, it is more needed than in court because there's no judge unless there's a discovery referee, because by that point the civility is probably gotten out of hand. But or incivility. So that's, but again, I still, that doesn't persuade me enough to include the amendment.
I'm going to discuss 3.5 because it's this one basically similar to what I've stated already. We did this one, we really felt pretty strongly about doesn't fit within the scope of Rule 3.5. So we didn't even actually suggest edits because we really couldn't come up with edits that we thought were appropriate here. But 3.5 is dealing with contact with judges, officials, employees, and jurors, and kind of ex parte type communications. And we didn't feel that the proposed addition, which was subsection C that's stricken, as a lawyer shall not engage in a pattern of incivility that is degrading to a tribunal. We did not believe that fell within the scope of what Rule 3.5 is intended to address, and therefore recommended striking it, along with the comment that was added. There were 2 comments this really task force proposed to add. For the similar reasons, we felt those comments did not really address the type of conduct that Rule 3.5 is addressing, which is focused on ex parte communications and related procedural issues when you're communicating with judicial officers. So I think we had a pretty strong consensus on this, but I will just pause in case others feel differently or want to weigh in.
I did want to point out in terms of the issues, I mean, the fact that it didn't fit was compounded by the fact that we have multiple interpretation issues with this. I mean, we've got pattern, we've got degrading to the tribunal, we've got the one instance of incivility. We talk about that, then we're adding this idea of a pattern on it. So the reason for that very strong stance, I think, was because there were so many issues with it.
So I'm going to now, I want to talk about Rule 8.4, the proposed amendments here. This is the one that, now I don't think the working group has thoroughly researched this issue, but unless others know, I am not aware of other states that have adopted a standalone civility rule. But if anyone knows of one, but I do know that multiple states have incorporated civility provisions in their rules of professional conduct, including in Rule 8.4, and even in California, Rule 8.4 subsection D has been applied by courts to address uncivil conduct. So subsection D is engage in conduct that is prejudicial to the administration of justice. That's already part of our existing rules. And so the Civility Task Force proposed adding a comment clarifying subsection D and making it clear that that applies to incivility. And there's a lot of redlining and highlighting in the comment here, so it's going to be hard for me to articulate clearly our proposals. But I think what basically COPRAC decided to do was take a lot of the recommendations that Civility Task Force had made to rules 3.3 to 3.5 and incorporate them in the comment, which is clarifying what subsection D, type of conduct subsection D would apply to, which is basically conduct that is falls within the definition of incivility. And so sorry, pausing. Make sure we still had concerns though, even with the red line language that we have in here. It's, and Hunter raised this earlier already in terms of, you know, we're saying repeatedly engaging in civility. And then there is a concern, well, does it have to be repeated, or what if it's one very severe incident? So should we have something other than repeated engaging in civility, or should we have severe or some other clarifying language here that that could constitute a violation of the subsection D?
One of the concerns about that repeated, habitual, all of those words, I mean, it's one thing to take an attorney in the context of a trial, or the context of a hearing, or even in the context of a given case, and say, well, you keep doing this one thing, you keep doing these bad things. But habitually could be your entire career. It could be everything you ever do. Repeatedly could be the same. And so we run into these interpretation issues.
And one other thing that we discussed, and I don't know if it's reflected clearly in this COPRAC comment summary, is some of the other language intentionally violated established rules of procedure or evidence. We had also discussed, does this need to be part of a disciplinary rule? Because if you are violating rules of procedure or evidence, there are going to be other clear remedies. So is it necessary to have that be an example as conduct that would violate paragraph D of 8.4?
I mean, I think that is Bill. And that's another one. Perfect trial judge can take care of that. You know, if you keep objecting in court's overruled you 5 times on the same objection, probably get sanctioned. Certainly, you know, reprimanded in front of the jury, but that's a situation where it's shouldn't leave it to state bar to deal with that. That's something that can be dealt with right there and now. And even if a judge does admonish counsel in front of the jury, do we want that? I mean, on my example, you've been overruled 4 or 5 times on an objection, and you keep making that same objection. I mean, that could be repeated incivility, but does that rise to the level of disciplinary action? I'd be hesitant to say yes. I mean, it's disruptive, sure. It's annoying, sure. I don't know that I would want to be subject to discipline for that, or even accuse someone else of disciplinary action for that. I mean, it happens because then you're trying to draw a line of maybe it's an issue you want to take up on appeal, but you want to make sure you have a clean record for it. We can talk about that in there, and you know, maybe judge isn't getting it for whatever reason. But that just seems to me that would fall within the category, but it doesn't seem like that's something that should be subject to discipline, which makes it vague. I mean, I think
Yeah, no, that's a very good example that you provided, because I mean, there are so many other issues that are involved there that raise just issues of interpretation, like I'm saying, because you do have to preserve the record for appeal by making the objection. So, and also the judge might not necessarily be ruling fairly in a situation. So you have to continue to make the objection. You're not trying to be in civil, but it could be, you know.
I've actually had, this is Hunter, I've actually had that exact experience. I was in a jury trial and my opposing party, the defense counsel, was trying to argue in the alternative, and the judge told her, you don't get to argue in the alternative. And I was very close to objecting on her behalf. Like, do we have to do a stipulated argument? She gets to do this. And the judge was reprimanding her And I felt that that's a situation where this could be claimed, but she was doing the right thing.
Yeah, I completely agree. I've been in situations sometimes where one time I was told by the judge, tone it down, counselor, when I was making an objection. And you guys probably know me.
Stop being so sure.
I am not the type of person who's super aggressive and was like shouting like, object, I was just saying that I thought fairly calmly, but it made it look like the record, like I was doing something improper when
when
the
you
judge
read the
told me,
record.
tone it down, counselor, for just making a legitimate objection. So there's a lot of,
That's interesting. That's a really good point because the transcript won't show, your tone and it's solely the judge's, comments and you're not going to argue back because then it will be legitimate. Yeah. Yeah.
I think this is Justin. I think this point is important enough. In the second sentence of comment 6, this protecting the record point, that I think we need to, I would suggest that we consider revising the second sentence because of that importance, but also because after hearing Ms. Wilson speak, I think we want to have simpler and clearer statements. In this second sentence, I circle 3 different things that are, I don't know what this means. And how's average Georgian gonna understand? The latter should not be conflated. Why don't we just say it's not a violation of the rule, right? So the first sentence says a lawyer violates by doing this. Why don't we just say a lawyer does not violate by doing that? And particularly by being more affirmative that we're saying it's not a violation of the rule to protect the record. I think that strengthens the point that we're concerned with, that lawyers have in the rule that yes, that they are not doing anything that's going to subject them to discipline if they're trying to protect the records. And then 2 other points on the second sentence. Conflated with an advocate. So maybe the word advocate shows up in the rules. I don't know, but why don't we just say lawyer or whatever, or attorney, whichever's the convention.
Lawyer.
Okay, so let's just do that. And then the third problem I have with this sentence is, can anyone tell me what patient firmness is? Because as a parent of a 2- and 4-year-old, I don't know what that is.
Did we pull that? I feel like we pulled it from the case.
Did it come from my case?
Just to be clear, this was not, I just want to clarify, this looks like it's highlighting, so this looks like it's Koprek's language.
It's not.
Just to be clear.
Oh, it's not a language.
So I want to be clear, I'm not being critical of anyone in this room, just to be clear.
We're just not away from this one.
No, not them either, not them either.
I
But no,
think
but in all
there's a lot of
seriousness.
cutting and pasting
Yeah.
here.
Yeah.
And because this was, so I think this was, like I said, moved from other proposals, like
In the
3.3
initial
to 3.5.
In the initial proposal that the subcommittee looked at, they had their recommendations, and then sometimes they'd have essentially their legal basis for it. If I recall, this was actually directly from a case where the court was using this terminology, which explains why it's wordy and hard to
Well, no, but I also, that might be right. And my recollection was too that, and I don't know where that, I know what you're referring to, Hunter, but I thought there was, the Civility Task Force had also looked at, or maybe other rules that have civility provisions. And I think this might actually be from another rule.
It's from the Alaska rule.
Okay, well, maybe that means something in Alaska. But I mean, really, hearing Ms. Wilson talk, how many of you think that patient firmness is providing clear guidance to lawyers?
It's
Here.
actually in several states' rules. So it's Alaska, Colorado, Delaware.
Oh, that's right.
Sorry, I'm just skimming through DC.
Patient firmness.
But what part? It's 8
word.
Start using that phrase.
I gotta get out of California more.
Expressing outrage over this term, and then after the meeting going, oh my gosh, there's a laundry list.
And
of
so we're
other,
just going to be perpetuating this,
that use it.
If you look at their
Right.
rules here,
Right.
it's probably
Yeah.
one dentist and they're just
Exactly,
follow.
just copied it, yeah.
It is absurd.
Right is like, oh, what?
So, Justin, just to get what you said in the beginning of the sentence on the screen, was it to say a lawyer does not violate paragraph D by standing firm, or?
Honestly, I don't remember.
That's what I wrote down.
A lawyer does not, so I was thinking something parallel, right? So a lawyer does not violate paragraph D
By
by standing firm in the position of the client, protecting the record for subsequent review, for preserving professional integrity by,
Yeah, period.
Yeah, period.
period.
Do the other states have this entire,
Before preserving professional integrity, right?
is it,
Period, I think.
Right.
Yeah.
is it the latter, is that, do the other state rules have
Which is
the
probably-
latter should, does it have that first sentence too?
So I'm just gonna, they're not all the same, but there's other language that we have already omitted. So refraining from abusive or obstreperous conduct.
Oh, remember that, that's right.
We didn't get that word last time, I
I'm
believe.
kind of Frankensteining this whole thing.
As a corollary of the advocate's right to speak on behalf of litigants, a lawyer may stand firm against abuse by a judge, but should avoid reciprocation. The judge's default is no justification for similar dereliction by an advocate. An advocate can present the cause, protect the record for subsequent review, and preserve professional integrity by patient firmness, no less effectively than by belligerence or theatrics.
I mean, it does provide guidance,
rules.
I guess. Yeah.
Justin, I feel like being on Zoom for so long, I've missed a lot of facial expressions.
My words don't convey my strong feeling about certain things sometimes.
The body language is part of
I mean,
it.
not to say that this is something that we should adopt, but it is used in, it's not just a few, it looks like it's in the several without counting.
Has it been problematic in those states? I mean, have they actually used it? Has it been useful?
It's not, so it's in the ABA model rule and it looks like it's in most of the other model rule states.
Oh.
So I
It
can.
sounded
I
like
can
something
count.
followed patient firmness in the.
Yeah, belligerence and
Yeah.
theatrics, yeah. I can.
Ending it
I can
at
send you the
patient
links
firmness
to
is.
get on this, but like-
Is it a trial
They clearly
theatrical?
did not discuss this. They just cut and pasted
Yeah.
every
Yes,
other rule. That's
that's
how
what
they
I think.
clearly did not discuss it.
I figured that out after I was like, voiced my outrage.
It's like a cancer.
What's more interesting, it's part of ABA Rule 3.5, which is impartiality and decorum. So to what you said earlier.
So we're against theatrics now, too?
Yeah, right. So it's not part of 8.4.
Well, so let me try to advocate here, not to conflate things, but preserving professional integrity, period, is broader than saying by patient firmness, and therefore I think is more
Oh, they have a.
appropriate for what we're trying to
They just
convey.
have a whole separate rule that makes it appropriate.
Yeah. Well, yeah, ours is duty of
I mean,
candor.
I don't wanna say
Yeah,
anything
the
that's
decorum would-
controversial, but this
would
patient
work.
firmness thing, I can see completely being applied disproportionately to men and women, particularly by more senior judges who are not like old gender
Like what Sarah just
stereotypes.
said.
Old senior judges.
Yeah.
Exactly, and my thought is like, I'm usually pretty chill, and when I do emote, people freak out because it's out of character for me, but compared to other people, I'm not doing it. And I think a lot of people and a lot of women encounter that. Whereas
Yeah.
people who are loud and boisterous and belligerent all the time, people know that's their status quo and don't think anything about it.
Yeah.
Erica, do you want me to just drop it on page?
Yeah, that or you can just share
So
this.
that
share the screen on
advocacy
it,
for
whatever.
removing patient firmness.
Yeah, I don't like,
And the whole title of the rule that talks about ex parte communications,
we're already expected.
really relating to that one comment.
To be patient.
Keep our-
Right?
This is a misconduct that we're talking about, so why would we put things in about theatrics
From 3.5.
into a
that we don't even-
misconduct? It doesn't match. You
No.
can't conflate the two.
It's,
Section gender, I think that's.
Yeah, and I thought you made a great point about decorum is not really the same thing. Sorry, we're just.
we're looking at rule 3,
We're looking at the
model rule
model rule.
3.5.
It's entitled patient
Oh.
firmness.
I'm gonna write a novel.
See that? Is that in a comment or?
It's comment 4 to ABA Rule 3.5.
Right, but an ABA 3.5, model rule 3.5 has to do with ex parte communications, right? And, but it's entitled impartiality and decorum of the tribunal. And so we don't even have a rule we don't even have a similar rule.
It does, if you look at 3.5D,
Can't get my internet.
which is the conduct intended to disrupt a tribunal, I'm assuming that's what the comment is tied to.
Yeah, that makes sense. in our rule, do we have anything?
Partiality to the form of the tribunal.
So California's rule 3.5, I don't think has similar language about disrupting the tribunal. And if you look at the background to California's rule 3. I'm looking at the right 3.5, that it says that commission declined to recommend the model rule which prohibits a lawyer from engaging in conduct intended to disrupt a tribunal. It's unnecessary in light of the commission's recommended adoption of rule 8.4D, providing it is misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. So it seems like California decided to go in a different direction than the ABA model rule.
Which is the direction that we also.
Yeah. So, sorry, getting back to, I think we've gone over all of the rules, and Angela, did you have a chance to make the red line edits that Justin was recommending?
No, I have not.
I think we should do those, because I think it would be helpful.
Justin, can you go over these?
A lawyer does not violate paragraph D. Oh, it'd be the second sentence.
Well, no, if you put it in the first sentence, it's far more interesting.
So it's with a ladder, right, with a where there's the ladder.
Okay, right here.
So it'll now say, a lawyer does not violate paragraph D. By standing firm. It's already there. By standing firm. You just get rid of the should be conflated with, yeah. By standing firm in the position of protecting, and then, yeah, and then delete by patient firmness. Yeah. Maybe it can be wordsmith a little bit better, but I think that is more consistent and clear relative to our goals.
And the only other thing that we had discussed is setting from the position of the client. I think we're going to end it, delete or preserving professional integrity. I thought we were supposed to strike that language, preserving professional integrity, which seems pretty vague, but what do others think?
I like it because it means there's another way that you're not violating. Otherwise, there are.
Right, protecting the record
Sure.
and standing firm in the position are ways of not violating the rule, but there are other things that you can do that would preserve professional integrity that don't necessarily fall under the number of those two items.
Yeah, that makes sense. Okay. So I think just kind of trying to get more to a finished product of what we're going to send, since we've gone over all the rules now. What I'd like to get feedback on from the group is, I know one of the proposals is to do a standalone rule, which we don't have, anything drafted at the moment, that would address incivility as opposed to having it part of many different rules. The other option that is described in this memo is having everything be part of this comment 6, So Rule 8.4, clarifying subsection D. Although the other issue that I just wanted to point out is when we discussed all the rule amendments as a group, it seemed that we were all generally in agreement with Rule 1.2, which deals with the allocation of authority. I thought that might be a helpful clarification that the comment proposed, especially there's a lot of frequently encountered issues that lawyers face where, just clarifying. I have to go back to the rule now, but I think Rule 1.2, our addition there was just to a comment, and it didn't seem as controversial. Just trying to get it on my screen, where we were just writing an example that a lawyer does not, or a lawyer may agree to reasonable requests of opposing counsel that do not prejudice the rights of the clients. I don't think there's anything problematic with that, and I think it's helpful overall in kind of promoting civility. But it seems like the committee as a whole had problems with almost everything else, although we have suggested revisions to try to clarify it. So I'd like to just get feedback on whether, putting 1.2 aside, whether we feel that we should try to incorporate some incivility proposals from the other rules as part of comments 8.4D or as a standalone rule, or do we feel that it's not appropriate at all? I know I just raised three.
I do have one more potential thought, and I don't know if this is necessarily a good idea, but I think it's one we should talk about. Ken mentioned the 2007 civility guidelines, and that's something that I actually have to I keep in my office and I refer to them. For whatever reason, the rules don't refer to them at all. And I was thinking if we wanted to refer people to civility guidelines, and of course, this would be essentially a reference within a comment, but in a comment, we could say avoidance of incivility that would be prejudicial to the administration of justice. Maybe refer to the guidelines on civility. That way, it's clear that we're not setting up a minimum standard that is a rule, but that we are putting some teeth in the civility guidelines by having a comment which are relied on as authoritative that refers to it. Again, this is probably a lot more watered down than what the task force is looking for. There is one idea.
It's pretty effective if you cite those guidelines, which I think are pretty good.
Who promulgated those guidelines?
State bar.
Okay.
I don't know which committee.
Right.
State bar.
So they've already been vetted by this very body.
Well, one would assume. I haven't looked into it too
Yeah.
deeply. I just made that assumption when I saw this.
But it makes sense.
Seems like if the idea is that state bar trustees want rule amendments to have a bite, then it should be a standalone. And then within the standalone, well, maybe a comment about the civility guidelines is to kind of bolster that standalone incivility rule. Seems like that would be easiest approach would be to do a standalone rule, as opposed to try and match it with how they've done it here so far. I mean, like 3.3 to 3.5, it just doesn't fit.
No, it doesn't.
So you just have it as a standalone, you don't have to worry about that problem. Bolster with the civility guidelines and good comments.
I like the civility guidelines because it creates a cross-reference opportunity for lawyers, and it opens, then it really does provide guidance, and it's not just like, how do I interpret this one rule that talks about incivility? Because you want to, promote civility in a more holistic way, and I think that's what that would be designed to do. Sorry, I didn't mean to. Go ahead.
I was just gonna say, so what's left after these discussions is limited to the comments. So there's nothing in the black letter rules themselves regarding civility, which is fine, but I just wanted to raise that because if there is a discussion of creating a standalone rule, are you proposing to take things that were rejected by COPRAC as items to put back into the standalone rule, such as the black letter that was in 3.3, et cetera, into a standalone rule, or are you is that not truly is that just a board alternative as opposed to a true recommendation of COPRAC?
Well, like, if you look at the standalone rule for discrimination, it says comment two to that rule says the conduct prohibited by paragraph A includes the conduct of a lawyer in a proceeding before a judicial officer. So it does sort of encompass, decorum in court, for the discrimination. So,
Right.
I mean, obviously we haven't started drafting a rule, or I don't even know if that's our task, but it just makes perfect sense to me to model it after what they already have here. I mean, why reinvent the wheel? And that's kind of, it just naturally feels right to me to have an 8.4.2 or whatever. Yeah.
Directly responsive to the question, I think a lot of the things that COPRAC is proposing to reject, we would propose to reject completely.
Correct.
And not to add into a new standalone.
Right. So that's what I'm hearing. So that's, I guess what I'm asking is because it seems like there was concern amongst the group of having these types of things as true disciplinary standard or just a species for discipline in a black letter rule, as opposed to what's in what is being proposed as comments is guidance, right? That's what the comments are. They interpret what's in the black letter. And so to the extent that this group has not actually wanted to include anything in the black letter, I'm wondering if this group truly actually wants a standalone rule at all.
I would be against the standalone rule, but I also think there's a separate, partly maybe because of, there's a separate rationale for having it in 8.4D comment. Because to me, without the comment with those sort of examples, administration of justice doesn't really include.
What does it include then? Yeah.
Now, this has come up before. And one of the things that comes up is you have some egregious case of somebody doing something totally crazy, and then you say, there's no rule against it. So if you then, with this comment, define the administration of justice to include some of these things, you also get to sort of Joel's comment before, which is, it has to have an effect. It isn't just not smiling at me, it has to affect the proceeding, the thing we're doing. That's administration of justice.
Oh, I like that. That's great.
I would be in favor not of a standalone rule, but in further clarification of 8.4 regarding prejudicial to the administration of justice.
Yeah, so
Yeah, I changed my vote.
so basically working on the comment that we revised a little bit, but kind of clarifying it even more probably and fine tuning it. But I support that as well. Because I think just as Erica pointed out, we run into so many interpretation issues when trying to make it part of a disciplinary rule itself.
Can I say something? If you insist, please do it in a, I mean, if it gets that far.
Right, like the second option should be a standalone
We're
rule.
not advocating it, but it would, be preferable to not having it if you're gonna include all of this anyhow.
Right, because the risk is that they're gonna say, it will just do it in one comment, 8.4, it's just gonna dilute the whole thing, what's the point, And I think we need to give them that option of a standalone rule that actually makes more sense than, I think it's just a bad idea to put it, interspersed through all the other rules.
The
So,
lesser of two evils.
yeah, exactly.
I also have one question about, since it seems like many of us are in favor of perhaps having it be a comment to 8.4, clarifying paragraph D, which currently the comment 6 uses the term incivility. Do we typically have definitions of language that only appears in a comment?
It doesn't, I searched the terminology, 1.0.1, and it doesn't appear that there's any current definition that only exists in a comment. Their terms are used throughout the
because then I think that we need to just explain what we mean in the comment. It should be part of 1.0.1.
And then the only other outstanding thing is whether you would still retain the comment that was added to 1.2 in addition to what's in 8.4.
Yes, so maybe should we take like a straw poll on both of these issues?
Separately.
Yeah, exactly. Yeah. So let's start with 1.2. How about if whether you're in favor, and if you could maybe bring that up to Angela to the screen so everyone can see it again. In favor of proposed addition to comment 1, which is shown in green highlighting, which would provide, for example, a lawyer may agree to reasonable requests of opposing counsel that do not prejudice the rights of the client, be punctual in fulfilling all professional commitments. Sorry, I'm trying to avoid offensive tactics and treat all persons involved in the legal process with dignity, courtesy, and respect. So could we just
Well, I guess.
Did I read it
now-
right? Did
Well,
I-
you did, but now I'm reading the whole thing. You parse it out. It says a lawyer may avoid offensive tactics.
Yeah.
Yeah, I mean, that's more like a should or shall, but
And that was, we used may because the preceding
Yeah.
sentence is talking about the authority to do that.
yeah.
Oh, may as you.
If you read it by itself, may is the same as may not.
Right. But you
Why can't we just say-
It's permissive.
It's, yeah, you
You're
have the
able
authority
to
to
do
do
it.
this. and it's
Can't we
called-
just say
Because-
this
okay.
include, this may
Like
include
can
agreeing
do
to, or something like that?
Yeah, may agree to reasonable requests of opposing counsel, not prejudice the rights of the client, and then take out the middle part.
We wanna
Include
s-
all people, persons involved. Well, I don't know if we need that part either.
We want to be like really express about what we're trying to accomplish here and say, notwithstanding any direction from a client, a lawyer retains authority to. Are we trying to be that clear?
Yes.
I like that.
That's great.
Yes.
Because this is like the client pressure provision.
Exactly, yeah,
It's raising it.
yeah.
Can we enact this immediately for my
Yeah, I know, exactly. And my clients benefit, that's, yeah, so it would be, yeah, so. I really like that too.
So, that was my earlier comment about what do you do? How do we address what you do when the client tells you to do something that otherwise would be on this list? And I like that. It's not a violation to ignore a client's instruction to do bad things.
Yeah.
And then second of all, since we're talking about civility, just as a personal request, trying to follow all this remotely, it's getting real confusing when everybody talks over each other. So just for us remote people, it would sure help if we kind of worked on that a little bit. Thank you.
Yeah, and I think
Thank you.
Bridget made the point, and I keep on forgetting to do it too, but we should all try to say our name before we speak too. I think you can't see us, is that right?
No, we can't see you guys. We can't tell who's speaking.
Yeah, so this is Sarah, and we'll try to be better. So does anyone want to make a proposal for revised language for this comment?
I propose.
I immediately forgot what I said. This is
Notwithstanding.
any direction a client may give instead of
Client's direction, notwithstanding the client's direction to the what?
a lawyer retains authority to, and then we have our list.
Notwithstanding a client's direction.
To the contrary,
I don't think
making
you
it
need to the
worse.
contrary.
I'm making it worse.
I like, yeah,
So that might, does that resolve, this is Sarah, does that resolve the issues that we had with like the language agreed, notwithstanding a client's direction, a lawyer? We didn't have may, I thought it was, but
A
Brandon
lawyer
just
retains
suggested
the authority to.
yeah,
yeah.
Brandon's just retain- yeah. That's what I thought that might solve the problems we were having with the
that's also
language.
like me, but no, I think that's right.
The lawyer retains the authority to agree to reasonable requests of opposing counsel that do not prejudice the rights of the client.
Be punctual.
That, it's not perfect, but I think that's workable.
Yeah.
It's
Yeah.
closer,
Yep.
right?
So I'm thinking rather than trying to tweak the language too much more, just maybe we can take a straw poll on just this concept recognizing that we might need to improve the language, and I'm sure State Bar staff might help could potentially help with that before it's presented to the Board of Trustees if we request that. So could we just take a straw poll on whether people as a concept agree to this type of provision as a comment, as comment one, in addition to comment one to rule 1.2?
Can I just make one quick comment? I think this belongs in here, no, regardless of the civility, I mean, I think that's kind of tangentially related to what they're trying to do here. I think this is an important revision. So let's take the poll and I will vote yes.
Angela, could you do the straw poll?
Yeah, I will. Sarah Vanola,
Yes.
Ken Bacon,
Yes.
Raquel Pittman Brown,
Yes.
Elizabeth Bradley,
Yes.
Cassidy Chivers,
Yes.
Brandon Krieger,
Yes.
Joel Mark. Joel?
Yeah, is this the question to accept it as it's now written?
Yes.
Yes, okay.
Eleanor Mercado, Bill Munoz,
Yes.
I'm a yes on that. I guess I originally understood it to whether it should be in here, but not necessarily as written, but I think I'm a yes as written as well.
okay. Daniel O'Reilly,
Yes.
Kyla Rowe,
Yes.
Hunter Starr.
Yes.
Okay, so it's unanimous.
Okay. And this is Sarah, just to clarify, Eleanor, that was my understanding too, that we were just talking about this the concept, recognizing that we might need to tweak the language a little. Which I think we should. I don't think we necessarily need to do this right now, unless other people would like to work on that, but I think it's in, with this revision, it seems to be workable. And I would propose that perhaps we, since this memo will ultimately go to the Board of Trustees for further consideration, and before it does, I think, Erica, maybe you can help me with this process, but is it something that Office of Professional Competence could work on tweaking it a little bit without changing the substance, or should we try to do that now? What are your thoughts?
No, you could direct staff to do that. It would not be able to have the entire committee weigh in on again prior to it being presented to the board, unless there was another meeting convened.
I mean, my take is there are three things going on in this memo. One is we're just trying to tweak as best we can what we've been given, which is what we're doing now. And we're telling them we've done the best we can with the time we have. There's still work to be done. Number two is we're saying we think that board or whomever, you should really consider whether it would be better to do all of the civility concept within Rule 8.4. And then the third part is, and you should also consider whether it would be better for your purposes to have a standalone rule. And I think we're already accomplishing that with this memo. So I feel like if we don't get this wordsmithing perfect, that's okay. It's still, we've done our job, which is to make it better from our perspective and then flag issues. So given the timing, I think that we might end up needing to vote this out with some statement that a couple things will be cleaned up consistent with the discussion that we had today.
Mhm.
And then we can send it in.
That sounds reasonable. So this is Sarah Vanola, and just to, I think, advance this further, I think we should discuss, since we had the straw poll and it was unanimous, on keeping the substance of the proposed additions to comment 1 to rule 1.2. I think I would like to now take a straw poll on a proposed comment 6 to rule 8.4 subsection D, that clarifies certain types of incivility that would fall within the scope of subsection D, or provide guidance on that. And we have recommended some changes to proposed comment 6, but similar to what we did with the comment to 1.2, I'd like to take a straw poll or whether people agree in substance to the substance of proposed comment 6, recognizing that it might need to be further tweaked and revised to avoid ambiguity. Comment 6.
Want me to take a couple
Yeah,
notes?
that'd be great. Thanks.
Sarah Bonola,
Yes.
Ken Bacon.
Yeah.
Raquel Brigham Brown.
Still reading, come back.
Okay.
please.
Elizabeth Bradley,
Yeah.
Cassidy Shippers,
Yes.
Brandon Krieger,
Yes.
Joel Mark.
Yeah, okay.
Okay. Eleanor Mercado,
Yes.
Yes.
Bill Munoz,
Yes.
Ann O'Reilly,
Yes.
Kyla Rowe,
Yes.
Hunter Starr.
Can I confirm something? Because there's the reference to rules that we're rejecting in there, I would assume that this poll is regarding the comment not including references to rules that would not exist.
Oh,
Yeah.
yes. And actually, could we,
Strike
I think we should just strike that now.
And my understanding was this is a concept vote.
Yeah, this was a concept vote, but just, yeah, I think it might be
That
helpful,
clarification,
For
yes.
clarity.
just so we don't overlook it later. I would, just,
Right,
it might
okay.
help out, Angela, if you could just strike that now. That is a very good point. But yes, we are just voting on the concept at the moment.
Yes.
Okay. And Raquel.
Yes.
So that's also unanimous.
Okay, so I'm trying to think of what, I don't know that we really need to take a vote on the rest, because I think almost everyone spoke on the rest of the memo. We're not incorporating the proposed changes.
Discourteous.
But that's in rule 1 point, maybe this is something Justin raises that we should address, because I,
Then we're gonna come back to that. decide.
well, I don't, okay, so let's go back, yeah, to rule 1.0.1 has a definition of disability, and I raised this previously, based on what we're proposing, the term incivility will not appear in any rule. It will only appear in the comment to rule 8.4D under our proposal. So I don't think it would be appropriate to have a definition of incivility that does not appear in the substance of a rule. It'd be inconsistent with current practice. And since we're not recommending that be part of a black letter disciplinary rule, I propose that we don't have a definition of incivility as part of 1.0.1, and instead we be clear about what we mean by incivility in 8.4, the comment to 8.4D. But I'll pause to see if others feel differently on that point.
Elizabeth, that makes sense to me. Yeah, okay. This is Cassidy, I agree. You can just move the definition into the comment. Incivility means, for purposes of this comment, incivility means blah, blah, blah.
This is Hunter. I was thinking just going a step further and just replacing the definition incivility with just using what it means in the rules. So instead of saying repeated incivility, we say repeated abusive, harassing behavior.
That's smart. I like that.
So, to that point, this actually would go to comment 8.46, but it actually, Angela, where you have it raises a good point. Do we need to have any of this First Amendment caveat language also included as a component of what's going to be in 8.46?
Yes.
Yes.
I missed that.
It's on the screen, right?
It's on the
now.
screen.
Yeah, so that was the proposed comment to 1.0. The incivility.
Oh, right. Got it. Sorry.
And I just want to make sure, this is Sarah, that those of you on Zoom, that point is clear. Which is a good point. Proposed comment 4 to the definition currently has some language that makes clear that it's not intended to apply to conduct protected by the First Amendment. And so the proposal is to move that comment to a comment to 8.4.
So are we gonna have the word incivility anywhere? No.
No, this would remove it, I think, and of course, we'd probably change the first couple words there, the definition.
Yeah.
Just say this comment.
I wonder, this is Cassidy, I wonder if the task force on civility is not gonna be happy about.
Yes.
They should change their name.
But
Well, maybe at a minimum, we flag for them the definition as we've tweaked it in our comments section to explain, if you're going to include a definition of incivility, here's where we think you should tweak it and the concerns we still have. And just move that down into our own comment section. And then if we don't need this, I'm not clear what we're saying, but if we don't need this comment now about incivility, about the First Amendment and all of that, based on how we're tweaking things, I think would still want to put that in our own comment section to explain as part of the concerns as to why we excised the definition of incivility, what they should keep in mind if they bring it back, so they don't lose the benefit of our struggling with this when they think about it.
Was there a decision about the reference to the guidelines or even to the oath?
Oh, yeah.
Well, that was, Hunter was proposing that.
I would think just at the end of it, so comment forward, include what we have now. We'd include, instead of the word incivility in what we have now, we'd include the definition. We'd include this caveat regarding the behavior that we're talking about. We're not looking at stuff where we'd be violating anybody's First Amendment right. And then at the end, for further guidance or review, the 2007 guidelines on civility.
Like lawyers are instructed to, refer to, or lawyers should refer to the guidelines on, something that is stronger than C guidelines.
It'd be a long comment is what we're getting.
So just this is Sarah, and I just want to make sure I understand what you're saying, Hunter. So what we currently have is proposed comment 6 to Rule 8.4, clarifying 8.4D, writing guidance on that. Are you suggesting that what's currently shown in comment 4 to the definition be part of proposed comment 6 as well?
Yes, so rather than say in comment 6, go down to it so I can just read straight from it. Rather than saying repeatedly engaging in incivility, we just replace that with the definition of incivility that they were proposed, or that we tweaked, repeatedly engaging in significantly unprofessional conduct that is abusive, harassing, while engaged in the practice, and finish out the definition that way, and then add on the portion as just another sentence. This is not designed to attack anybody's First Amendment right. That would be the comment. So both that definition from that rule and the comment to that definition would be subsumed, or would be within comment 6 on 8.4.
Okay, I understand. And so the other question I wanted to raise is the current comment 4 has additional language. I don't know if we need or would like to include. This definition includes, I think the rest we only need the first sentence that appears looking at the screen from comment 4 to be part of proposed comment 6. I don't think the rest of comment 4 applies.
Right.
Yeah. Okay.
Ange, I can send you some text in just a second.
Okay.
And then the final addition to the comment would be potentially lawyers should seek guidance from the guidelines on civility.
Which you've already sworn to. No, I'm just.
Can I put it in the chat?
It's true, right?
What do you want me to add it, Erica, on 6?
Not
It would
everyone
be
has.
new.
Not yet.
This is like
Yeah.
new 8.4 comment 6.
You could advertise that you're a lawyer who has not yet committed to the civility guidance, so hire me.
Not in 1999.
For certain categories.
Not found by this.
So should we, I'm sorry, I know I'm doing a lot of these votes and I'm not sure, because I'm not clear on what, if we need to, but do you think we should take a straw poll on the proposal that Hunter kind of just articulated, which I can state more clear, I could try to state more clearly for the vote purposes?
if you give Angela just a moment, I think what Hunter was saying will be on the screen.
Perfect, and then we can look at it and take a vote on what's on the
Yeah.
screen.
With
That would be perfect.
typos and brackets for the civility guidelines, but otherwise.
Okay, that sounds great, thank you.
Discourteous is still in there, but you can discuss whether or not you want to retain that or remove it.
And this is Sarah again, I think, I know we're gonna be, as Angela's putting that up, the final thing that I think I just wanted to try to get agreement on is, I think then we've kind of gotten to the substance of the main points of this memo, but I think it's going to require some cleanup in the background section and the intro, which I don't think we need to reach, vote on as a full committee. I think we should just authorize staff and the working group to kind of add language to the background to reflect the revisions we're recommending, consistent with the revisions we're recommending. Because right now that the background of the discussion doesn't really articulate that. It talks about a standalone rule, which is what we discussed in the last meeting. So I want to make clear that that's not our can't think of preferred method. Our preferred method is a comment to 8.4. And as an alternative, it would be a standalone rule.
Agreed.
Okay.
Take a poll on that.
Oh, yeah, so it looks like, thanks, Angela. So if everyone could look at the shared screen.
You have to remove the word definition, so this does not apply to conduct. In the last sentence of the first paragraph.
This definition would not apply.
This does not, yeah.
And
Take out definition.
Got it.
And the other thing is, I think we should take out, well, maybe this requires a vote now. I thought, we also were talking about taking out discourteous.
Right.
Yeah.
I thought we had agreed to that already, but.
I think that's right. I just was in the.
If it-
This is Dan, this is jumping ahead to the last part, but would anybody else agree to say something like a violation of the 2007 guidelines is prejudicial to the administration of justice?
I think that creates a bright line rule that poses.
That opens up.
This is Bill, I mean, maybe put may, that would give the fluff that you need, but I think that opens another can of worms.
Yeah, and this is Sarah, I'm concerned about that too, because I know that some of the civility guidelines, I mean, they're intended to be guidelines, and there are certain things that I feel like you should meet and confer with counsel, for example, before filing every motion. And that's not necessary. I don't think that rises to the level of discipline if you don't meet and confer before a particular motion. And I think we're trying to address repeated or pervasive incivility through the rule. So I don't want to say that just a violation of a civility guideline would necessarily.
100% agree. I would actually say may is even too strong. I think that it should be a reference because the guidelines cover so much and so little of it, at least in my view, should rise to disciplinary conduct, standing alone. So I would be in favor of first kind of writing that up as a reference guide before we talk about it may create discipline for violation.
I propose the language, this is Hunter, I propose the language, a lawyer should consult.
Yes.
Yeah.
A lawyer's failure to consult.
I'm just reading them for the first time, so.
So, one follow-up question, this is Erica. So would it make more sense to put that a lawyer should consult the California Attorney Guidelines of Civility and Professionalism above the a lawyer does not violate? Or I'm just does the order of what's on the screen make sense?
I agree with Erica, what you're proposing, that it should follow, does not violate, or sorry, lawyer violates paragraph D. as a second sentence, I guess, of this comment.
Yeah.
I just wanted to raise one concern about referring to civility guidelines is, and particularly where I do think it fits in that place, but I'm afraid that it could be interpreted by referencing them. We could be implying that it is a violation if you're not following them, just by referencing them. And so I am somewhat, I'm a little concerned how we make that clear, that we're not saying, but I don't have a solution, but I'm just flagging that issue.
And one of the reasons, this is Hunter, one of the reasons I suggested a reference and a comment is because it would be scary to essentially create rules out of the guidelines. That would be a lot. But I think that if we just say for guidance, see these guidelines, it would give courts or the state bar, it would give them some sense that these are guidelines that attorneys should be aware of, they should be consulting them without having the teeth of a rule that's going to, in and of itself, create a basis for discipline. So I think it gives it just enough teeth where it is, without suggesting that it's a rule. And given that they'll have, I would assume that they would consider the background of how we came to